Peace and grand rising to the sovereign, original, indigenous, natural, divine heirs. Today is July the 28th, 2022 on the Greco-Roman calendar, 1442 on the ancient moon calendar, and 1443 on the ancient sun calendar. Can you all hear me okay? Is it loud enough? I just want to be sure. Okay. To the one who's putting that in the chat, you may want to check your volume on your end, because it seems like everyone else's volume is working okay. So with that being said, all rise and stand and remain standing into perpetuity. This is a sovereign living ancient Article 3, Al-Moroccan, Moorish American, World and Earth Court action. We are the sovereign living justice in capitis diminution nolo, in red ink, in propria persona sui juris, in proprio solo, and in proprio heredes. I am sovereign living justice, Pauline Denise Ritchie, in capitis diminution nolo, in red ink, in propria persona sui juris, in proprio solo, and in proprio heredes, and my free chosen sovereign appellation is light to jure, and it is also, I am also in capitis diminution nolo, in red ink, in propria persona sui juris, in proprio solo, and in proprio heredes. All Moors are the original indigenous, sovereign, ancient Al-Moroccan, Moorish American ascendants of the great pharaohs of Kemet and of the ancient Moabites and Canaanites. Our full faith and trust, our allegiance, our credit, and our energy are hereby vested in ourselves, for we are the people who are the original indigenous, natural, divine, sovereign, ancient empire state for Morocco. We are the de jure Moorish National Republic federal government. We are Washington, ancient district for Columbia, the Universal Moorish American Consulate, and the Article 3 Moorish American Consular Court. Today, we are executing the law, establishing and executing the law by our sovereign capacity, which is the original indigenous, natural, divine, sovereign, ancient Article 3, living United States District for Columbia Bankruptcy Court. And we are the sovereign fiduciaries, secured creditors, executors, trustees, ministers, claimants, and beneficiaries in this cause for action. We are peace. We are one nation, one state, one empire, and one God. We hereby accept our sovereign ascension and exercise all sovereign rights at this time and at all points in time, nunc pro tunc. Before we begin the bankruptcy proceedings, I want to point a couple of things out more that you can do that we have also initiated and done in our territory. First, let me show you, this is a photo from 1936 where we have talked about this flag that's at the top. This, and it's not a flag, it's actually a banner for Amity and Commerce. This one right here that we're showing on the screen that looks like a backwards, it looks backwards, but it's actually, theirs is backwards. The United States Corporation Company did a backwards version in order to pretend to do commerce on our land. And I found a photo from 1936 that was placed on the record where they were showing the changeover. And they were saying, okay, they were getting people accustomed to seeing it this way on the left, which is backwards. Whereas with the red arrow pointing, this is the way that it was initially. This is the way when we were the living United States Corporation Company and the living United States and the States United. That is how it was, that's how we showed that we were doing commerce. Okay. And then in 1936, this is where they were getting people accustomed to seeing the changeover, so that whenever they got rid of this flag and moved it off of their commerce, then they would only show this one and have people pledging allegiance to this one. Okay, so I just wanted to point that out first, and I'll put the link to where this was found in the chat. Oh, thank you, Nobility. Here, let me do that right now. Here's the screen, and this is the photo that we're talking about. And the title of this, where I found this photo, is Let's Look at the Record, 1936. Okay, and they put here, they put both of them there so that if people saw it one way or the other, it would not change anything for them. Okay, so this is the backwards, and actually the one on the left is the one that's actually backwards, the backwards banner of Amity and Commerce. And then this is the one, the original forward Amity banner for Amity and Commerce that we put out for everyone to let them know that we're doing commerce. We're not in our government. And I can't say we're not in our governmental capacity because we always are, but we wanted admiralty law, sovereign living admiralty law, to be properly stated. Okay, so this is where they started putting this on the television and on the, you know, out in front of people everywhere, so that when they saw the one that was hypothecated, that they wouldn't think anything of it. Okay, and so the source for this information is in the chat. So another thing that I wanted to show you quickly before we begin, and really this is all a part of the bankruptcy proceedings simply because we're properly identifying where the fraud took place, how it took place, who's the fraudulent party, and so on and so forth. Another something that I wanted to show you just one moment. Is this. Just one moment. Okay, so on the screen, there is a notice. One moment. Moores has been speaking about a do not detain order. Okay, and Moores have been doing things to try and get themselves put on a do not detain list, quote unquote, not realizing, and we honor, let's just say this, we honor every Moore who has done that demonstration in whatever way they knew to do it. As the fiduciaries for the bankruptcy proceedings, we have the authority to use any of the resources that are involved in the bankruptcy proceedings in order to further protect the bankruptcy proceedings and to further secure all of the properties and things that come with the bankruptcy proceedings. So we have here a public notice, protected person status by the City of Federal Way, and it has the signatures of Jim Farrell and Andy Huang, who were previously in the office of mayor and police chief of police, rather. And we have it stamped by King County Superior Court, of which that is an inferior court that is subject to our Article 3 courts. And it's dated July 13th, which is the day of the full moon. It says, public notice, protected person status, no contact order. Notice is hereby given by the City of Federal Way to include the mayor's office, the police department, and the city council for Federal Way, that the following person is protected at all times retroactively as stated by the trust of the people of Federal Way, for whom said person does provide public service. All protected persons and their property shall not be contacted, approached, detained, or violated at any time in accordance with the Federal Way revised codes and all other applicable laws, to include the supreme law of the land. And then it has the name of the protected person. And more, as you know, we don't have names. We're not persons. We are the fiduciaries for all persons with names. And then all letters, all numbers, no matter what color, no matter whether they're capitalized or not, are under the sovereign fiduciary authority of the fiduciaries, who is all Moors are fiduciaries. So the things that I'm doing here today and showing here today and sharing are things that all Moors can do, because all of us are not only the fiduciaries for the state, and the state is the ancient sovereign state. All Moors are also fiduciaries for any persons. That's any capital letters, any colors, etc. Okay, and any of the resources of this bankruptcy proceeding, because as you know, things like corporations like City of Federal Way are bankrupt. Okay, and so because they're bankrupt and we are the creditors, we have the authority to receive and utilize anything that has to do with the bankruptcy proceedings in the way that we see fit, in order to continue to serve in our governmental capacity. So, and you know, everyone is aware of this. All persons are aware of this. Okay, they know this already. They've always known that we had the authority to do the things that we're doing, and that is another reason why they went ahead and put anything that had to do with signatures and things like that on the public record. We're the fiduciaries over all signatures. Okay, and as you know, we do autographs. So, and then those former custodians have copies of this, and this is also being put on the public record again here today. So that's one remedy. And again, fiduciaries have not just the authority, but we as the fiduciaries have the obligation to secure ourselves and the other Moors who are asleep. We're obligated to do that. We don't have a choice in that matter. We have to do these things. We have to. That's not a choice. And then the Moors who are incarcerated, we have to do the same for them. Additionally, here is another document. This document is also done by the City of Federal Way. All municipal court cases voided in favor of Pauline Ritchie. And again, Pauline Ritchie is a tool that is used, and we are the fiduciaries for all tools. That is another reason why we did the Declaration of for Independence this past Sunday in the call that we had previous to this one. In the Congressional Assembly, we voted on that and put it on the public record. And then we physically took a copy of that and gave it to the subjects. To whom it may concern, notice is hereby given and stated for the corrected public record by the City of Federal Way to include the Mayor's Office, the Federal Way Police Department, and the Federal Way City Council that all Federal Way Municipal Court judgments against Pauline Ritchie are hereby voided entirely, retroactively, and forever in the favor of Pauline Ritchie, and all court records cleared of any and all alleged charges and warrants with regard to all City of Federal Way municipal court cases in accordance with United States law, the Constitution for the United States 1789 and 1791, the Bankruptcy Act of 1933, the Emergency Banking Act of 1933, House Resolution 192 of 1933, statutes for the Territory of Washington 1855, Federal Way Revised Codes as placed on the public record by the original Indigenous Living Federal Way, United States Department of Justice Tax Non-Obligated Public Law AA 222141 for all commerce, Supreme Court rulings, and we do know who the original Indigenous Supreme Court is, and all other applicable federal and state laws. This public statement includes the following non-felony cases. And in this case, Morris, just know that non-felony, it means that all cases are non-felony cases when it comes to the Moors, simply because never once did we fall on our knees, because that's what that word comes from. Fell on knee is what that means, is did the sovereigns submit to those who were previously pretending to be corporations? Did we submit? No. Never once did we do that with full disclosure. So non-felony cases, 7V0714492, 7V1201571, and 1A0250975. Only our courts have the authority to void cases that were previously done by a bankrupt corporation. As a part of the taking of the possession of these resources that are already ours, this is one of the actions that we are obligated to take. We don't have, this is not where we this is not something where we have a choice. We must do this as the fiduciaries. A competent court does competent things such as this, which will further secure the heirs, because there's been some, confusion and war with regard to who these all caps are and who are the fiduciaries for these all caps. It says here, none of the alleged non-felony charges were a serious offense as defined in RCW 10.77.092. We are going into subject matter just a little bit here, but we can because this is a court. It says, we hereby correct our records accordingly. And when we say we, we're talking about us and all inferior courts. That's why this stamp is here. So their records are corrected also. And then we're correcting the public record by putting this on the public record. It says the following additional information supports this public statement. Supreme Court judgment in favor of Pauline Ritchie in the above stated causes of action with an award of $100 million to Pauline Ritchie due to the following actions and or omissions on the part of the City of Federal Way Police Department. A, lack of jurisdiction. B, failure to properly identify the person. And C, failure to state a claim. The City of Federal Way, the bankrupt one, did not have a properly stated claim. We proved that. Okay, we proved that by going in, even when we were in those of the cell. Okay, when we were in the cell, the cell automatically became an Article III court, automatically. And I hesitate to call it a cell because it wasn't a cell the minute we showed up. It became a court. And in that court, we stated the claim properly as to who we are. And when we did that, they had to open the door, which we opened the door. We just gave the command and the door was open. It took 10 days of us continuing to state who we are and standing no matter what. But that's what it takes sometimes, okay? We must stand no matter what. And when we do, then access to the estate in this manner is granted to us by us. We are the only ones who have the authority to grant access to the vast estate. So then we went ahead and followed up our proper claims as to who we are and properly identifying ourselves with court actions that awarded $100 million to Pauline Ritchie. Number two, the status of protected person does retroactively belong to Pauline Ritchie as affirmed by the Supreme Court due to her public service and the trust placed in her by the people of the United States, the people of Washington, and the people of Federal Way. The United States, Washington, and Federal Way are living original indigenous entities, beings, not entities, but beings, living, breathing beings. It's not a dead corporation as stated by a dead corporation, okay? So when we state these things, it's living, it's sovereign, it's original, it's indigenous, but it has to come from us and it must be placed on the public record. When it's stated by the dead, then they're talking about dead entities and not about us. It says further, all protected persons and their property are protected at their stated will and shall not be approached, harmed, detained, or violated at any time in accordance with the Federal Way revised codes and all other applicable laws to include the supreme law of the land. Placed on the public record on July 13, 2022. Stamped here, King County Superior Court, and the signatures of Jim Farrell, previously custodian in the office of the mayor, and we are the mayor for Federal Way. We're also the police chief for Federal Way. Okay, always have been, Moors. At your territories, you're the mayor, you're the police chief, you are all of those offices, okay? You always have been. And, you know, no one can subrogate your identity, nor your creditor status, nor your benefits, unless you assent to that. And we do not. We state on the public record today that we never have and we never will assent or consent to any of that. So we've placed this on the public record. We're placing it on the public record again today. We have done previous court actions with regard to this, but Moors, you can just, again, put the documents on the public record that state who you are. Do it in red ink and all lowercase letters. And that way you can capitalize anything else that comes your way. This is a prime example of capitalization. Capitalization is a form of commerce, whereby we use capital letters to move resources back and forth. With these documents, we have moved $100 million back and forth because we know that the dead city of Federal Way doesn't own anything or have anything. They're bankrupt. Okay, so this is a part of the bankruptcy proceedings, as it were, because it's proving that it's pointing out that they're bankrupt. But we're going to look further into the codes, the statutes, the law, the supreme law for the land, and further provide this information so that Moors, you can do the same thing at your territories. And when you go out on the public record, you will find the signatures of the custodians, because they were the previous custodians, because they were told to put them out there. So you'll find them. We have every signature ever given. We're going to prove that again further as we look at the documentation and move further into the bankruptcy proceedings. So now we'll also provide, this has been posted on my Facebook page at Like to Jure Facebook page, this documentation that's on the screen. So you can see it there, or I will put the link to it, and I will put the link to it under this video for you to look at, to download, and to use how you choose to use it, more in terms of putting your own letters together. Okay. So let's look now back at the bankruptcy proceedings so that we can properly state on the public record what's going on in terms of bankruptcy. In order to know how to handle the abundant prosperity that is our vast estate, we, the creditors, shall competently execute due process in order to receive our inheritance by unified identification, claiming, receiving, accounting, and responsible use of our vast estate and the resources thereon. We must be competent, and we state today that we are competent to identify ourselves as the creditors and not the debtors. We are competent to peacefully receive the properties, conveyances, etc., and continue to secure the estate for our future heirs. That is the purpose of this universal court action, which shall be ongoing in the best interest of the creditors, who are the ancient, original, indigenous, Moorish American, Al-Moroccan heirs to all land, all natural resources, and all commerce. So these bankruptcy proceedings have been ongoing and will be ongoing. We're giving them, this is going to be called bankruptcy proceeding number 1. And as part of this first bankruptcy proceeding, step 1, part 1 rather, proper identification of the parties is the first step that we're taking today. Who are the creditors and who are the debtors? Then we're going to prove that the said corporation was a corporation and is bankrupt. And number 3, we're going to provide creditors' proof of claim, which is one of the initial steps in bankruptcy proceedings. So facts in this cause are all United States Corporation Company entities are bankrupt. What does that mean? That means that it doesn't matter whether you're talking about a grocery store, a fake court, policy enforcers. It does not matter schools, churches, any 501c3s, they're all bankrupt. Every one of them is bankrupt. Banks, they're all bankrupt. Anything that you can think of on the land that was pretending to be a government or a corporation or pretending to provide a service, this includes utility companies and all retail. And I will say this too, just so that the record is clear, and this is why we said at this time we need to not do this, which is do not file anything with the United States Corporation Company. Don't file anything under them, okay? There are temples and mosques and entities and businesses that are filing things, and they're not stating by affidavit who they really are. Therefore, they're putting themselves in debtor status. Okay, and that is why we did not do any 501c3 anything with regard to the Moorish National Republic federal government, nor our courts, nor any of that. We didn't file any documents where we were saying this is a something of organization. All of that we did on the public record by our own courts. Okay. Anything that was filed under them, we're going to show you why. So let's move forward so we can look at exactly why we did not file anything under them, such as articles of incorporation and all of that. We didn't file that under the United States Corporation Company. We put it on the public record coming from our court. Number 2, only an Article 3 competent court can provide the remedy and relief. So that's another cause for this, another fact about why we're doing this cause of action. Competence is proven herewith by the presence of this sovereign congressional judiciary, which is all more that here, what we're saying and that are on this call. You and we are the sovereign congressional judiciary in our fiduciary capacity on the public record. And again, that is all Moors. Okay. As we have stated previously, it is the fiduciary's responsibility to take control of or marshal all assets comprising an estate or trust, especially when a fiduciary assumes office at the grantor's or testator's death. Well, the United States Corporation Company, the dead one, has been dead since day one. It was never living. And that means that all of those black all caps that they were using were dead too. So we had to say, all rise and stand, and let's do this the right way. Let's state who's who are the creditors, the living creditors, and who are the dead debtors. And that's a part, that is one of the first steps in a proper and competent bankruptcy proceeding. The prerequisite to immediate access of certain accounts occurs, and for us it's of all accounts, occurs when the fiduciary provides, just one moment, let me move that back just a little bit. When the fiduciary provides a court affidavit of authorization and produces a death certificate. Okay, the fiduciary document that we have placed on the public record is that authorization. Our nationality documents is that authorization. Okay, so a name change in judicial proclamation. If you do nothing else, declare your nationality on the public record. Okay. That's going to ensure that your status as the creditor is published as a part of due process. Okay. And then producing a death certificate was necessary. And the United States Corporation Company produced death certificates called them birth certificates. But those were really certificates stating that whatever entity identifies with that birth certificate is dead. So we had to properly rebut that with living birth affidavits. And those will be under this video at Light to Jure Bay channel on YouTube as well. Most of the Moors on this call, you've seen those and put them on the public record for yourselves. Additionally, any natural living person to whom the office of fiduciary of any state is so transferred shall, for all the purposes of this action, become and are deemed to be the trustee for the state, and the person from whom the office was transferred shall be deemed to have resigned that office. And that is why the letters, the resignation letters have been placed on the public record, and we will continue placing resignation letters on the public record as a part of these bankruptcy proceedings from those offices, or actually the custodians who were previously in those offices. The dead have also been pronounced as such, and all other debtor office holders are hereby resigned. The link to the death certificate and fiduciary documents are here, and I'll go ahead and put this in the chat, and we will also just take a quick look at the death certificate once again for those who had not seen that death certificate. So let me go ahead and put that in the chat. Just one moment. Can you all see the screen? I just want to be sure that you can see it. If you could just let me know in the chat that you can see the screen. Okay. We put the link to the death certificate and the resignation letters that we have gotten so far, gotten together in terms of those who have resigned. Okay. So now let's just take a quick look at the death certificate. For the purposes of these bankruptcy proceedings, as proof of death, thank you in the chat. Okay, Islam. Okay. Okay, I'll go ahead and unlock the meeting as well for those who are wanting to come in. Locked. Okay. So here on the screen is a copy of the death certificate, July 4th, 1776. Regarding the United States Corporation Company and all agents, principals, heirs, assigns, and any and all derivatives thereof. It says deceased person information. Name of deceased is the United States Corporation Company, and all agents, principals, heirs, assigns, and any and all derivatives thereof. Date of death, July 4th, 1776. Place of death, Washington, D.C., North America. Cause of death, natural causes. And it has the signature of Joe Biden on it, who was the former custodian. And then it also has living natural person, which is myself, as the president and chief medical examiner for these proceedings. So I'm the presiding, but again, I'm not doing it alone. You all are presiding as well. So we're all doing this together. And that's another reason why we show these documents, is so that you can create these documents for yourself and put them on the public record for those who choose to preside in these types of proceedings. Okay. Everyone has the same stamps and seals, so you can take the stamps and seals and put them on the public record as well on your documents. And then any other stamps and seals that we use, all Moors can use them. And then here is the resignation letter. That office, the president office, is an office that we hold. And when I say we, all Moors hold that office because we're the ones who created it. Okay. And it cannot be unlawfully occupied. Okay. So, just one moment. Now, I'll give you just a moment to read that. I'm going to go ahead and secure it. Okay. And while you're looking at this document, again, this letter serves as notification and affirmation that the Honorable Chief Justice Pauline Denise Ritchie, and again, that all Moors, your appellations go there as well, has accepted the appointment and titles of President and Fiduciary Officer for the United States in accordance with the Office of the President of the United States, the Office of the Treasury, the Constitution for the United States, 1789 and 1791, the Bankruptcy Act of 1933, the Emergency Banking Act of 1933, House Resolution 192 of 1933, U.S. Department of Justice Tax Non-Obligated Law, AA 222141, for all commerce, Supreme Court rulings and opinions, and all other applicable federal and state laws. It is the fiduciary's responsibility to take control of or marshal all assets comprising an estate or trust, especially when a fiduciary assumes office at the grantor's or testator's death. The prerequisite to immediate access of certain accounts is the fiduciary providing a court affidavit of authorization and producing a death certificate. Additionally, any person to whom the office of fiduciary of any state is so transferred shall, for all the purposes of this action, become and are deemed to be the trustee for the state in lieu of the person from whom the office was transferred, who shall be deemed to have resigned that office. The bearer of this letter is entitled to 100% immediate reimbursement or discharge on all commercial obligations and transactions with national identification bearing the United States Department of State Tax Non-Obligated Public Law, AA 222141, as stated by the original indigenous Moorish American state. All financial instruments presented by the original indigenous American people that are properly autographed with two signatures, one of which shall be from the Office of the Treasury, Janet Yellen, and the other autographed from the bearer of this letter, shall be honored in accordance with the stated laws and the power and authority vested in the Office of the President and the Office of the Treasury for the United States. All authorities, duties, responsibilities, and benefits for the Office of the President are hereby transferred. It has been an honor to serve, and that is signed by Joe Biden, Jr. And then we have authenticated it with our stamps and seals. It is also further authenticated by the King County Superior Court, which is a court of a lower court, constitutionally inferior court as deemed by this Congress. And that's constitutional language. Article 1, Article 3, and Article 6 of the Constitution. So, let's see. Now, further, just one moment. Let me ensure. Now, I want to show you also, heirs, some other things that we, just one moment. Yes, I can open the meeting. Just one moment. Okay, the meeting is open as well. Thank you, Nobility. Okay. So now let us move on in the proceedings, and this way we can properly further properly identify the United States Corporation Company. And when we properly identify them, we will know by what we see that they are not a lawful entity on the land. Okay. So now, this court and the fiduciaries in this cause do hereby stand and activate competent, peaceful governing of the bankruptcy cause against the United States Corporation Company, the dead one, in the favor of the people. This cause does hereby begin on this day of the new moon, July 28, 1442, which is the moon calendar, 1443 on the sun calendar, and 2022 on the Greco-Roman calendar. So these are the facts in this cause of action so far. We're going to put forth a few more as we move forward. And again, as we know, all businesses, companies, and corporations are bankrupt, regardless of the size or who is claiming to own it. Each and every one is deeply in debt because they organize under a debt system and continue to operate under said United States Corporation Company, Federal Reserve debt note system. Therefore, the U.S. Treasury and its agents, principals, heirs, assigns, and all derivatives thereof are in debt permanently. What are the agents, principals, etc. of the heavily indebted U.S. fiat system? All other corporations that were pretending to be governments, such as government of Europe, government of Russia, government of Japan, government of Israel, government of Washington, government of, any of those are all debtors. Pauline Denise Ritchie, in all capital letters in black ink on their paper that they produced, was a debtor. So we had to produce the creditor, which is the natural person, and we have done that. These are so in debt that they cannot pay the debt back. Their debt is so massive that it cannot be restructured because there is no counterparty that is willing to accept the debt as the creditor in a debt system. There's no such thing as a creditor in a debt system. So if for those who are using Federal Reserve debt notes and using the forms that were created by the debtors, you're not a creditor, you're a debtor, because you're using debt instruments in order to say anything, in order to speak. So default on the debt is not an option because the debt is too massive with no leveraging or buying power to salvage. So the only other option is that we, the sovereign secured party creditors, stand and remedy the issue by way of our courts. Now, over the years, Moors have done things actions and things along the lines of what we're doing today, we honor them. Yes, when we say, Justice Kansu, thank you for that question. He said, what about the UK? The United States is the UK. You all are a state, and you're united with us. So all states. Did you know that there's a United States of Great Britain, or United States of Europe? There's a United States of Mexico. There's a United States of Canada. There's a United States of Africa. There's a United States of, what else? There's a United States of Antarctica. There's a United States of the Arctic. Those are all one with us, okay, in their original indigenous living form, not form, format. So we are all one. There's no part of the earth that's not one with the United States. So when we say United States, we're saying it from a universal standpoint, not a lowly corporate standpoint. Because that's where the fraud happened, is some small corporation of dead persons was claiming to be the universal United States, which is all states, all original indigenous states at Earth. So we're rebutting that fraud and putting that thing, we've already put that thing in its proper place, which is the grave. And now we are governing the resources. I want to send a huge thank you to our Grand Sheikh Taj Tariq Bey, who kept insisting and stating and declaring and proclaiming that we get our courts active. He knew years ago, before most of us were even awake and before some of us were even born, he knew that it was through our courts that these bankruptcy proceedings could actually manifest, so that we can freely and properly and competently and peacefully access that which belongs to us, which is all resources on this land. Okay, so we want to send a huge, gigantic thank you from the farthest parts of our heart to him for continuing to put that forth, that we needed to have our own courts. We have them, we have honored his word, and for that we are grateful to him. We owe him everything. We owe him our ability to implement and activate and do what we're doing now. We owe that to him because he stood and sacrificed and ate sandwiches and noodles to keep telling us this truth instead of, you know, selling out for fiat. So we want to send high honors to him for that as we move forward. So we want to put this question forward as we move through these bankruptcy proceedings. The question is, have we, the heirs, filed a valid secured creditor's proof of claim in order to collect on the bankruptcy of the debtor, the United States Corporation Company, and its agents, principals, heirs, assigns, and any derivatives thereof? The answer to that is yes, we have. Okay. That had to be done through sovereign Article III competent courts. It couldn't be done through a court where there's a foreigner on the bench. So those who have been doing consular court duties, and there are some who've been doing consular court duties for many, many years, our participation in that has been to make the consular venue more public. It's not that we ever stopped governing, it's that we needed to make it more public earthwide. And so that has been one of our goals in activating in the manner that we've activated. So what is proof of claim? Why is proof of claim necessary? And how is that done? So what we did was, we looked at the Federal Rules of Bankruptcy Procedure, Rule 3002. I don't know about you all, Morris. Many may have known this already. But I did not know that there was actually, and I had seen them briefly when I first woke up, but as always, the ancestors will give us a piece of the puzzle or a piece of the process, because it's not really a puzzle. We're not puzzled by it. It's a piece of the process, and then they'll show it to us, and then they'll say, okay, be prepared, because down the road, you're going to be looking at this and activating this. So there are a separate set of federal rules of bankruptcy procedure. And I'm going to put the link to that in the chat so that you can look at it more and see this. Here, and we will go there now on the screen as well. Thank you, Empress. Yes, that is it. I already hit the button, but that is absolutely, yes, Islam. Thank you, Empress Angel, for putting that in the chat. That could have saved me a step. Thank you. So, Morris, the Federal Rules of Bankruptcy Procedure here at United States Courts on the screen. We needed to take a look at these because we want to competently place the process on the public record so that we won't keep having the issues that we had previously, where Moors were claiming domiciles and conveyances and things like that, and policy enforcers showed up. Okay, we need to nip that in the bud so that our heirs won't have to deal with that, and so that we won't have to deal with it. So what we want to do is look at the Federal Rules of Bankruptcy Procedure and implement them. In looking at these, we first, as with all court actions, we need to first, before we even go into these, look at what we have learned and what we know about court actions and proper identification of the parties. So what we did, many of you have this already, but let's just take a look at it in the interim, where proper identification of the parties is concerned. We want to take a look at who the United States Corporation Company is. (28 U.S.C. 3002). Let's take a look at that really quickly. Because, again, we need to properly identify. 28 U.S.C. 3002 says, United States. United States means a federal corporation. There it is, in plain writing. B, it says an agency, department, commission, board, or other entity of the United States, or an instrumentality of the United States. So that's how we know that Federal Reserve debt notes is an instrumentality. And if the United States that has some paper circulating, if that paper started with a dead entity, then that's a dead United States, which is different from a living United States. An original indigenous United States is different from a dead United States. And again, anything on this landmass that does not come from the living heirs is dead. So this United States right here, this goes for the living or the dead. They were both corporations. They are both corporations. Okay? We are a living United States, which is the States United. When you're talking about commerce, okay? When you're talking about commerce, United States, and for those that are at the other lands, the UK and the other lands, this is not a geographical designation like we thought it was. It does not mean this, it doesn't say anything about land here. That's why the United States Corporation Company, the dead one, was able to go act out, going everywhere and warring on all lands, talking about they're the United States, this, that, and a third, because it's not a designation in terms of geography. Okay? It's a designation in terms of instruments, instrumentality. So it doesn't even say anything here about politics, about political parties or anything like that. A federal corporation, corporations do commerce. That's what corporations do, is commerce. We have living commerce that's done lawfully with real money, and that real money is real because it came from us. And then there's dead commerce and debt. Debt and death are the same word. That is why we can say without blinking that Moors do not have any debt at all. We are the living. So this is proof here that that dead entity was indeed a corporation and not a government, by definition. Okay? Yes, lost at sea is dead. Islam in the chat. So now, we want to further identify the parties. We have in our possession, and most Moors have this in their possession, but we want to make sure that we show this. First, let us say we want to thank the webmasters at moorishemac.org for staying the course and keeping these papers on the public record. There are others we know who have put these documents on their websites. We thank you as well. We are specifically mentioning moorishemac.org because this is where we found these documents yet again. We had them in our repertoire, but I did a Google search just to see if it would be found on the record. And as I had suspected, Google takes certain ones of us, depending on what we search, to a different place than it takes those who are just out there asleep and searching things. Okay? So let me put this link in the chat so that we can take a look at the incorporation papers of the dead United States Corporation Company. Because again, this is the beginning of the bankruptcy proceedings. We need to properly identify the parties. And first, their identity is not even based on what they say, it's based on what we say. Just like our identity is based on what we say. Let's take a look here at these documents. And again, we thank moorishemac.org for their website having these documents available. So this is Articles of Incorporation filed on July the 15th, 1925. Moors, it's been almost 100 years. Almost 100 years. And what we're doing is so important because after 99 years of this thing being on the public record, had we not rebutted it properly, then there would have been a perpetual clause that kicked in for them. A perpetual clause. Perpetual means that is going to be, you know, supposedly would have meant that this is a perpetual corporation into perpetuity. And you can see some of that language in these documents. We won't take the time to look at it today, but please do take the time to look at it and discuss it among the groups, your study groups and your consular groups and your judiciaries. Study the documents so that you can see what's being said here. And also know this, Moors. This is going to be a little bit controversial, but we are going to say it anyway. These articles of incorporation are, number one, they're fraudulent. That's not the controversial part. But number two, we have to actually put something on the public record to rebut these, where commerce is concerned. So what we're doing is, first of all, we're stating that we're putting it on the public record as coming from us. And second of all, in the coming days and weeks, we will present our articles for incorporation with regard to commerce on the land, so that, and we will be taking the language straight from this document, just like we did the treaty, just like we did the Constitution and all of that. Those things are not valid unless we put them on the public record. This is not valid until we put it on the public record, and then we must implement. And we cannot, and one thing we know this, we can't say that they're frauds and not produce the real, the living, the truth. Okay? So that's what we're doing with everything that we do. We know that they didn't think of anything new. There's nothing new under the sun. So what did they do? They just looked at what we did previously, and then they put that stuff out there, and then they suppressed and recessed. Okay? And that's at our consent. They couldn't even do it without our consent. So these are the articles of incorporation, and notice this incorporation number right here, 800-00255-5948-7. Okay, that's a number that we've placed a lien on that number, and we placed a lien on this number, and we placed a lien on these articles. Okay. And I apologize that this is not bigger. Here, I'll make it bigger. Now, I want to, again, we're properly identifying the parties. We've identified them as the fraud because we're the living and we're right here. So we're properly identified by our presence and by our nationality documents on the public record. And then that automatically identifies them as the fake, the fraud. It says here, Certificate of Incorporation of the United States Corporation Company. Filed in Office, Secretary of State of the State of Florida, this 15th day of July, AD 1925, and then it is signed. Now, the Secretary of State, it says by W. This W right here, we've seen this before. This is actually a Masonic symbol. And the one that was doing business as George W. Bush used this symbol as well for his initial. He wanted it to be known that this is who they are. Okay, they don't represent the Moors; they represent the dead. It says here United States Corporation Company, and it lists Cedar Street in New York City. International Corporation Company is what it says here, and then it has Los Angeles, Philadelphia, New Jersey, Albany, New York, LaSalle, I want to say Louisiana, but I'm not sure, St. Louis. This is where they were saying, okay, this is where we're doing commerce. Okay. So again, proper identification of the parties in black ink and capital letters. Let's just point that out and be sure that's noted for the record. That is what this is. Right there on the screen, July 25th or July 15th, 1925. And please note that our Prophet Noble Drew Ali had already done some things that made it so that they needed to put this on the public record if they were going to continue to hypothecate. But there were some further steps that we needed to do. So that's why our Prophet knew that. That's why he said, if I told you the half, then many would go back to sleep. He knew that there was another half that he couldn't even deal with at that time. That he also said that in the 2000s, the Moors were going to come into their own. So he knew we were coming. He prophesied your and my coming. So we honor our Prophet Noble Drew Ali for the things that he did, the work that he did, and all that he gave in order for us to know what we know now and to do what we're doing. Okay. And then you can see here, certificate of incorporation. Now, Moors, just notice that they did their own certificate. They didn't go and purchase a certificate from someone else. They typed up a certificate themselves. That ought to tell you, that ought to tell us that we have the authority to create all that we need to create in order to further assert our sovereign status. And then they took it to State of Florida Corporation, okay, and got it stamped. And in reality, in order for this to even be anything, we actually had to stamp it. So we don't know which state of Florida this is, do we? We know it's fraud, so we know it couldn't have been us. But this state of Florida is bankrupt too, if the truth be told. So as we look further, I just wanted to point a few things out about these documents. And then the route that they took is the same route that we have taken in order to do the things that we do. Okay. 1913, which was what, 12 years before, 12 years prior, they did the Federal Reserve Act so that they could start putting their own quote unquote money on their documents. Okay. That had to be done before they could start doing any commerce and all of this kind of thing, because they cannot do commerce with our money. We have to do commerce with our money. And we cannot do sovereign living commerce with their money, because theirs is not money. It's military script. It's not real money. And we do real commerce because we use real products and we are real people. So they had to do the Federal Reserve Act and create their own fake fiat. And then they said, okay, now we can talk about 100 this and 100 that. And I just want to point out here, it says the maximum number of shares with this corporation is authorized to have outstanding at any time is 100, each of which shares shall have a par value of $100. That is, and that sign there, we don't even know what that sign is. We don't know what that sign is because it looks like it's a dollar sign, but I don't think that that's what that is. It looks like an 8 with a top and a bottom to it. So anyway, we could go into the particulars, but we won't take the time to do that. Again, we're properly identifying the parties. It says at number 4, and I wanted to point this out, the amount of capital with which the corporation will begin business is $500. Okay, capital has to do with the letters that are on the script. That's why they talk about their script and capital in the same sentence. It has to do with are they in control of the letters on the script? Are the letters capitalized? Yes, they are capitalized. So these are the documents. Then they had, you know, if you'll notice here, they have addresses on here, but no zip code. So they were attempting to show some form of sovereignty by not using a zip code, even though they say that the zip code system came into being in 1963. But how could they do anything on the record without a zip code, but then turn around and tell you that your sovereign mailings have to have a zip code? No, they do not have to have a zip code. Okay? And we can prove that. I want to put something, we can prove that they know that. On the screen, Moors, is a copy of an envelope that came in the mail from the city of Federal Way. And again, they're in bankruptcy and we're liquidating. So they had to pay postage. That tells you that that's not a government, because government doesn't pay postage. Okay. But then they put on here this care of 911, and they put it in ancient English, 911 Southwest 314th Place, Federal Way, Washington, reservation, and then latitude and longitude. There it is right there. Okay. And it still got where it was going. Now, that tells you that whenever someone says to you in a quote unquote post office that, oh, this has to have a zip code on it, we can't get it out without a zip code, they're not talking to you. They're not talking to the sovereigns, nor are they talking to the custodians, the former custodians. That is for United States corporation company citizens. They need a zip code. Okay, so now let's we have identified the parties. Okay, and this document does not even say anything about Washington, D.C. It does not say anything about Washington, D.C. It says state of New York and the laws of the state of Florida, 1925. Okay. And they made sure that they noted New York County, New York. Okay, so we need to, I just wanted to point a few things out with regard to them and what they were doing. And in the future, we may present a few more things with regard to this document from them. Because again, we're liquidating. Okay. Just one moment. Let me make sure I'm not missing anything that's going on in the chat. So again, proper identification of the parties. The parties have been properly identified. And anyone doing business that was previously doing business by way of this corporation is bankrupt. Okay? There it is. The name of the corporation is United States Corporation Company. Bankrupt. All day, every day. So, with that being said, we have properly identified the parties. Now, what we want to do from this point forward, next to the signatures, it has LS. I see that. For commerce, yes, Islam, in the chat. Now, we do not know what LS means with regard to their signatures. We know that the dead cannot claim to be living unless this was done by a Moor. But let's take a look at that really quickly. LS, this might mean legal standing or legal status. Okay. For us Moors, when we autograph, we put in capitis diminutio nolo in red ink in proprio, or we put all rights exercised at all times. We write that out so that there is no question about who's who and what's what. We don't, just as Morpheus said, lack of soul. In this case, again, we don't know what that meant for them. We just know that this entity is bankrupt and that we are liquidating any of the claims that they made because their claims were not valid in the first place. That's number one. Number two, we needed to properly rebut the claims in order to move forward so that the Moors are protected. Okay? And that's what we mean when we say we protect ourselves. We protect ourselves by competently stating all that we need to competently state on the public record. So with that being said, again, we thank moorishe for having those documents up on the public record. Other incorporation papers, based on the language that is in that document, birth certificate, social security card, military ID cards, anything that's issued by anyone other than the Moors, okay? And the Moors that issue documents and documentation need to properly rebut any 501c3 or any claims under the United States Corporation Company. Because believe it or not, Moors, you can be a 501c3, but you cannot be a 501c3 under the United States Corporation Company. You can be a sovereign living ancient 501c3, which was sovereign and living and ancient before any foreigners ever even came here. because again, there's nothing new under the sun. So that you can claim the benefits of a 501c3, sure, you can do that, but it cannot be using their forms and filing under their system. You notify the custodians and the subjects that you're a 501c3, but you do that by affidavit with sovereign autographs on the public record. Because as you can see, anything that they created is bankrupt. And you don't want to file, you don't want to use their forms because those forms are tied to a bankrupt account. And that's another reason why, you know, we've seen Moors doing a whole lot of things, and we honor the activity. We definitely honor the energy and the activity. We must be competent to know that our word is first. We don't need their approval. They only offer opinions, even according to the Declaration of Independence. It says the opinions of mankind, not the law. Mankind does not, their only law is us. So I looked through the, here, let's go back to the bankruptcy rules, the federal rules of bankruptcy procedure. I did a little study on them in terms of proper claim and also of proof of claim. So, more, this is how we do things, just for the public record. They have here on this website, this United States Courts website, a proof of claim form. So what did we do? We didn't fill out the form. We clicked on it and we looked at the form and we said, okay, this is the information that a proof of claim should have on it, pretty much. And again, proper identification is first. Who's the debtor? Okay. And then who is the creditor? So what do? We do an affidavit on Moorish government letterhead, and we just put these things in here. Who's the creditor? Has this claim been acquired from someone else? No, it hasn't. We've always been the creditor. Where should notices and payments to the creditors be sent? We have addresses. Again, looking at the fiduciary document, we had to properly claim the addresses, but as you can see, a mailing location will work too. We just showed that. Okay, so Moors who use mailing locations, you should keep using and insisting and producing accordingly. Yes, if Empress Angel says that looks like the liens that we've already done. Just know this, Moors. We're going over this process, but 99.9% of it is already done. The work is done. You've already done it. So we're not starting a whole new bunch of documentation. We're not. Really, the purpose of this is to put the bankruptcy on the public record competently, saying, okay, we did everything that we're supposed to do because this is our land, this is our stuff. We're showing to ourselves and to our heirs that we are doing everything competently and properly, according to the things that we have put on the public record. Just one moment. Okay. It says here, where should notices to the creditor be sent? Where should payments to the creditor be sent? Now, I'll say this about the payments part. If you will notice here, They're not asking for a bank account number. That should tell us something. Where should payments to the creditor be sent? They're not asking for a bank account number. They're asking for a place to mail payments because they know that payments are not in fiat, and they can't be in fiat. They can't be in fiat. They can be in credits, or they can be in documents, paper, dollars, real money, gold coins, gold. But most likely the payments will be in documentations that we take. Well, our courts have to produce those documents because a bankrupt entity cannot produce those documents. They can't. They're bankrupt, and when you're bankrupt, all of your actions and commerce and activity is terminated by the creditor, because the creditor does not want you creating even more debt while you haven't paid the debts you made in the first place. So, Federal Rule of Bankruptcy Procedure 2002G, you can take a look at that. Okay, it says, does this claim amend one already filed? The initial bankruptcy filing is whenever we say it is. We put it all the way back to the beginning, 1776, on the death certificate. And we can put it all the way back to time immemorial, or we can put it back to 1925 or 1913. We can put it for whenever we want to put it for. Okay. But we for the purposes of this cause, we chose 1776 because that's when they make all of their claims. They have something called the 1619 Project. But again, nunc pro tunc. We do everything nunc pro tunc. So we chose 1776, but nunc pro tunc means any time, now for then. Now for 1666, says the QV Act. Now for then. So we're not missing any beats on our proper due process where bankruptcy is concerned. It says, do you have any number you use to identify the debtor? Sure, we do have that. Moors, you can use any number that you want to use. You can use a social security number, because that's a debtor number. You can use the numbers on this incorporation document that we just showed. Our liens identify the numbers of the debtor. So again, we're not filling out this form. We've already done the work. We just want to point out that the work is done. Moors who filed lien affidavits, you've already done the work. You just need to continue doing it, that's all. How much is the claim? It is ad infinitum, actually. There's no number. You can start it with 100 million. I started it with 100 million. But that's 100 million per event. And that number is adjusted based on what we say and what we do. An event is a social security card. An event is a birth certificate. So that's 200 million right there. In other words, you can put unlimited there on your affidavit, not on this form, because again, this form is tied to a debtor account. So we don't fill out the form. You can use, yes, Empress Chitali says their EIN, and put the sign at the end. You would use a minus sign for their EIN. You're using debtor numbers. You know, the Social Security number with minus signs is a debtor, as produced by them. Okay. Any number. There's any number. The number of a passport, the number of a driver's license. Those are all debtor numbers. And they're all account numbers too. Also, Morris, any court case number is a debtor number. Okay? So, again, our estate is unlimited. It's unlimited. I mean, when you think about the amounts that's why our estate is called a vast estate. And then it says, what is the basis? What is the basis for the claim? Here it says, attach a statement itemizing interest, fees, expenses, or other charges required by Bankruptcy Rule 3001 C2A. You can do that. I would encourage you more to go look at Rule 3001 C2A. We're going to look at some of the rules here shortly as well. But go look at it and then know that you have the authority to change the rule and edit the rule according to your sovereign authority as fiduciary. Because as the fiduciary, we actually get to state what happens with this cause of action. What is the basis of the claim? They're saying, example, goods stolen, money, loans, lease, service performed, personal injury, wrongful death, credit card, et cetera, et cetera, et cetera. The basis of the claim is, it says here, wrongful death. We just say unlawful occupation. We can say death of the debtor. We can say death of the debtor is a good one, and that's what we are putting forth, that the debtor has died, and that we, according to the treaty and according to the Constitution and according to the bankruptcy laws and the House resolutions and codes and statutes that we have elevated to law, that we are liquidating the estate. Okay, and again, the debtors didn't have an estate, they were just claiming one. Is all or part of the claim secured? Yes, the claim is secured by a lien on property. Now, this is on their form. This is why the lien process, let me tell you more, is when we first published the lien process, we received so much blowback and so much resistance that we knew it had to be correct. It had to be right, because there were too many, there were even, you know, those claiming to be Moorish temples and, you know, Moors, you know, some were claiming to be ones who know, been doing this for 30 years and, you know, liens, la, 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 la. You don't need to be doing liens. That's an act of war. No, it's not. It's an act of peace. Okay? The war is when frauds try to claim something that's not theirs. That's theft. That's fraud. That's war. The claim is secured by a lien on the property. Now, this is number 9. First of all, look at what number this is, because they know that any proper liquidation of a bankruptcy is based on that. There has to be a lien on the property. So whenever they would pretend to take us into fake courts and assess a court cost, they were really essentially pretending and acting out liening their property. Okay? That's what all of that fake court stuff is. They were claiming, and if you pay court costs, quote unquote, in a fake court, and don't use lawful real money, then you're saying you're admitting to being property of that court. Because that's not even real money. It's not a real court. You're the court. You lien anyone claiming that trying to capitalize you. Lien them by sovereign affidavit. And please don't use their forms to lien them, because they already put a loophole in their forms saying if these forms have our names on them, because we invented this, because we crafted this form, we can throw it in the trash. So that's why we use affidavits. And then here it says nature of property. The nature of the property is, where is the property located? Out in nature, it's on the land. It's not in a corporation, it's on the land. And then it says here, I mean, they're telling us what to do, you know, and when I say telling us what to do, they're not telling us what to do. We're getting hints that lead us to the fact that we've already done what we need to do in order to liquidate and secure. Okay? Nature of property, all they're saying is, where is it? Whose property is it? Does it have the nature of the dead, or does it have the nature of the living? And that's why we speak by affidavit, so that the nature of our property is known and properly stated. It says, if the claim is secured by the debtor's principal residence, res ident, we're not residents either. So a debtor is someone who claims to be a resident. If the claim is secured by the debtor's principal residence, file a mortgage proof of claim attachment with this proof of claim. The debtor's principal residence is actually the residence that belongs to the principal that the debtor belongs to. The debtor has a principal, okay? That's the United States Corporation Company. The debtor's principal residence. It doesn't mean that this is the primary residence of the debtor. Debtors can't own anything. That's why they don't say debtor's property. So again, we are just properly identifying in this process and stating that we are competent we're competent fiduciaries to continue moving forward. Here it says motor vehicle. It doesn't say car, it doesn't say automobile, it says motor vehicle. And then other, described. Basis for perfection, because the liens have to be perfected. Our liens are already perfected, by the way. It says, attach redacted copies of documents, if any, that show evidence of perfection of a security interest. For example, a mortgage, lien, certificate of title, financing statement, or other document that shows the lien has been filed or recorded. That is how you perfect a lien, Morris, is file and record, and it has to be done with a competent court. That means when you record your liens and you place them on the public record, it's perfected. Don't let anybody tell you any different, because filing it with a court that hasn't been liened and them taking those documents, you need to lien any of those that were doing business as county courts and municipal courts and all that. You need to place a lien on the fake corpses, so that they know that they're the debtor and you're the creditor. And then when you place that lien on them, you raise them from the dead and put them in subject status. All that can be done with one court action. One lien that's done as a court action. And that's already been done, Morris. It's been done. We have those documents on the public record. The lien on the United States Corporation Company will be under this video in the links. Just click any of the links under this video at Like to Jury Bay channel on YouTube. So we've done that already. Therefore, proof of claim is on the public record. Okay. Let's see. Yes. We've been just listening to the ancestral energies leading us through the process one step at a time. And now that we're looking at these bankruptcy proceedings and actually implementing and activating these bankruptcy proceedings, the reason that the ancestors prompted us to go ahead and activate and liquidate is because they knew, the ancestors knew within us that we had done all that needs to be done. And that's why we encourage you, Moors, please put the documentation on the public record. Lien the social, lien the nom de jure, war names. Place liens on all of that. Okay? And that way, they can't keep using that stuff. Okay? Now we use what we want to use and what originates with us. And those documents that I showed you at the beginning of this call, for example, let's see, what was the other document that I showed you at the beginning of the call? I showed you the letters from City of Federal Way. Because in reality, we are the original indigenous City of Federal Way. So just one moment. Let me... make sure that you can, okay, good, you can see that. So, just one moment. So when we showed you this letter, we have no problem putting this letter on the public record because this tool, Pauline Denise Ritchie, this tool is a tool that should be working for us, not against us. But it can only do that when we properly rebut the fraud that was using it previously. Okay? So everything is a resource for us. So now let's go back to proof of claim and see what that looks like. So here, Rule 3002 of the Federal Rules of Bankruptcy Procedure, filing proof of claim or interest. It says, a secured creditor, unsecured creditor, or equity security holder must file a proof of claim or interest for the claim or interest to be allowed except as provided in Rules 10, 19, 3003, 3004, and 3005. A lien that secures a claim against the debtor is not void due only to the failure of any entity to file a proof of claim. So, Morris, even as we were doing the liens, whenever we were doing the liens, there were some who did not know to file proof of claim. That does not void the liens, okay? Nothing voids our liens except us, and we're not going to void our own liens. So it says the place of filing a proof of claim or interest should be filed in accordance to Rule 5005. Now, let's take a look at that really quickly because that's important. And again, we just want to take a look just one moment. At Rule 5005. This is some of the study that we did this week. Because again, we're talking about proof of claim and where to file it. It says here, place of filing. The list, schedules, statements, proofs of claim or interest, complaints, motions, applications, objections, and other papers required to be filed by these rules, except as provided for in 281409, shall be filed with the clerk in the district where the case under the code is pending. The judge of that court may permit the papers to be filed with the judge, in which event the filing date shall be noted thereon, and that's that date stamp that we have on our documents, and they shall be forthwith transmitted to the clerk. The clerk shall not refuse to accept for filing any petition or other paper presented for the purpose of filing solely because it is not presented in proper form as required by these rules or any local rules or practices. Let me just clarify for the record, we are the clerks, okay? Those custodians or former custodians at King County Superior Court are not the clerks for us. We are the clerks. They are subjects. And then anytime that they are acting as pretending to be clerks, then they're acting in a bankrupt status, which they can't do, which we do not consent to or assent to. And in fact, we've terminated that. All of their commerce is terminated. Therefore, they're continuously doing whatever they're doing as subjects of the Moors. So it says here, the clerk shall not refuse to accept for filing any petition or other paper presented. We first have to accept our own documents, Morris, and then we send them and send notification on the land. Okay, that's plain and simple. So the place of filing is with a court. It does not say here United States Court. It says the clerk in the district where the case under the code is pending. This is Washington District for Columbia. This is a proper district, but you're at proper districts also, Morris. These are ancient districts. They're not the districts that are done by the dead. These are living districts. The judge of that court may permit the papers to be filed with the judge. You're the judges and justices as well, Morris. Okay. So this doesn't list a geographical area. UK Moors, you're the judges, and that is a proper district that you're at. So all you do is put it up. That's what the public record is. The public record is a court docket. That's why they put properties and all of that. They were acting that out for us. Because the public record is a court docket. And anything on it is subject to court action. It's court action. And when it's coming from our court, it's not subject to anything or anyone but us. Whoever it is that put it on the public record is subject to them. They're the author, which makes them the authority. So at the beginning of this call, we said that we were going to do three things. Proper identification of the parties. Who's the creditors and who's the debtors? By virtue of us even having this meeting, we're stating who the creditors are and who are the fiduciaries, who's the court, and all of that. Fiduciaries have an obligation to step forward and begin fiduciating. We have an obligation to do that. Yes, we're the creditors and beneficiaries also. But we're the only ones who can even say that. And then we identify the debtors. Now, we showed you where the debtors identified themselves in 1925. But we're the creditors. Okay? Prove that the said corporation was a corporation and is bankrupt. We've shown that they're incorporation papers. Okay? Let's prove that they're bankrupt. I could do that with any of our documents, by the way. I can prove that they're bankrupt with any of our documents. Any document that the creditor has put on the public record and said they're bankrupt and invoke bankruptcy laws is proof that they're bankrupt. But the fact that they're using Federal Reserve debt notes says that they're bankrupt. So every time you see a debt note, you know that the producer of that debt note is a debtor, a bankrupt debtor. So I could pull any of our court actions that state that we're the creditors, and those documents will also be under this video. So we know who's the creditor and who's the debtor, and proof that they're bankrupt is the fact that they're using instrumentalities that are not creditor instrumentalities. And then you can also look at any of the treaty and the Constitution. The treaty says that when citizens die, that the consuls are to decide what happens with the property. That's because all U.S. citizens are debtors. Those who are debtors are always in the servant capacity and the subject capacity. They have to be because they owe a debt. So just by virtue of them being a servant says that they have a debt. It's just a matter of what that debt is denominated in. Okay. I have a debt to this sovereign nation. That's why I serve this nation. That debt is not a fiat debt. It couldn't possibly be a fiat debt because our nation doesn't use or accept fiat. So as a servant to our nation, of which we all are at our own, as soon as we state that we are, then the debt is being filled as we serve. We serve our heirs and our ancestors. And all at the same time, we are our heirs and our ancestors. So when we serve them, we're serving ourselves as well. Okay? So we've proven with our statements and our documentation who is the debtor and that they are bankrupt. The way that they do business says that they're bankrupt. We can also point to court cases, quote unquote, from 1952, 1954, 1956, with regard to nationals, United States nationals in Morocco. That case study talks about them being debtors, citizens being debtors, and the United States being a debtor. Okay? And then provide creditors proof of claim. Is there any other way, Moors, and this is just a question for you, that we can prove that they're bankrupt? Now, we know that their whole banking system proves that they're bankrupt. They say it on television and in their news media all the time. They talk about the debt. If you use even $1 in debt, you're using a bankrupt instrument. And it's not even $1, it's a Federal Reserve debt note. The use of one of those says bankruptcy because it was created by a bankrupt entity. We can also point back to the death certificate that we created that says that they're bankrupt. Provide creditors proof of claim. So, Morris, I want you to look at what we just showed, where it says the clerk shall not refuse to accept for filing any petition or other paper presented for the purpose of filing solely because it is not presented in proper form as required by these rules or any local rules or practices. I want you to put a pin in this part right here. The clerk shall not refuse to accept any filing for filing any petition, so that I can show you what I did with regard to that. So let me see. By the way, Morris, I wanted to show you really quickly with regard to the United States fiduciary documents. Let's see. And again, this is a proof. This is their proof of claim document here. When you're looking at these documents and you're thinking about the affidavits that we do, right down here at the bottom of the document, this basically says it all. Part 3 of this document, where proof of claim is concerned, says it all. It says the person completing this proof of claim must sign and date it. Your signature and the date on your affidavits is proof that what you're saying is true. But it says here, check the appropriate box. I am the creditor. That's the only thing, that and your autograph is the only thing that makes any of this other stuff true on your affidavits. But again, it's a trick bag if you try and do it on this form. So don't do it on their forms. Do it by affidavit. It says here, I am the creditor. And either you're going to be the creditor or it's saying I'm the creditor's attorney or authorized agent. That means you don't have any authority because you had to be authorized. It says I am the trustee or the debtor or their authorized agent, Bankruptcy Rule 3004. Trustees are, they pay the bills for the debtor, okay? And so for where our estate is concerned, all we do is we take care of the obligations. And so as opposed to being trustee, we're fiduciary, which is a trustee office, okay? But what we're doing is taking care of the obligations of the estate because we have no debt on our estate. And then what we're doing is liquidating anything that debtors were claiming. And that's another reason why trustee and debtor go on the same line. Okay? And we'll take a look at Rule 3004 in just a moment. I am a guarantor, surety, endorser, or other co-debtor. Surety and co-debtor, same thing. This right here is how Moors were ending up getting themselves into situations. Okay? We must properly state that we're the creditor. Okay? And our statement of being the creditor is determined by the place that we file as the creditor. Their forms automatically file anyone claiming to be a creditor under debtor status. That's what their forms do. Because they created it. You don't want to be held as surety. You don't want to be a co-debtor with them. So let's look at Rule 3004 with regard to debtors and trustees, etc. See, while we were asleep, debtors were filing claims and claiming to be creditors and trustees. It says if a creditor does not timely file a proof of claim under Rule 3002C or 3003C, this is important, the debtor or trustee may file a proof of claim within 30 days after the expiration of the time for filing claims prescribed by Rule 3002C or 3003C, whichever is applicable. The clerk shall forthwith give notice of the filing to the creditor, the debtor, and the trustee. So, as creditors, we are filing proof of claim properly with our courts so that no debtor can file proof of claim. That splitting of who's filing has been the issue. Because again, debtors cannot file proof of claim in a debtor situation, in a debtor economy, and claim to be a creditor at the same time. Now, for the purposes of this bankruptcy proceeding and for any and all that was done, where it talks about creditors not filing in a timely manner, this court has already stated on the public record nunc pro tunc, which automatically obliterates basically this, any claims that say the Moors didn't file in a timely manner. Anytime Moors file, whether it be prior to today or after today, is considered timely by this court, which means it's timely by all courts, because bankrupt courts don't have any say in that. They're bankrupt. So no matter who the Moors are, no matter whether it's Moors here, there, or anywhere, if you are of the bloodline and birthright, you can file proof of claim anytime you choose to do so, and it will be considered timely. Okay? That is, we've been stating that from the very beginning, with regard to the documents There's a question in the chat that says, what color writing for our documents to file proof of claim? Nobility, we pretty much already filed proof of claim. It can be now for the purpose of those who are doing fiduciary duties. Okay, there are some Moors who only want to claim their nationality and they don't want to do anything else. They just want to go about their way. They want to claim nationality. They can file in whatever color they want to file in. We've already provided fiduciary protection for that, for the documents. Okay, the fiduciaries, we have put the documents in red first, then in blue, and now, as you can see, with these types of letters, this is what we kept the black for. This is what the black ink is for. Is as we are doing our fiduciary duties and implementing things according to the bankruptcy proceedings, we use black ink to properly state the instruments by which the bankruptcy is the liquidation is occurring. So this is one of the first acts of liquidation, is protection, okay, in black ink. These again, our documents are in blue or red. Like my affidavits, I put all the red ones on the public record, and as I'm doing commerce and admiralty, I'm doing them in blue. So let me show you really quickly the document that I did. Let's see. Okay, so this is a document right here that I did recently. Hopefully you can see it. Let's see. Just one moment. Let me pull this one up on the screen. Just one moment. Okay, there's the document. So this is the document that a couple of weeks ago I said that I was going to render unto Caesar that which is Caesar's. We were talking about that on one of the calls before the recording started. And I said that I was going to give back to the the corpses all of their fraudulent documents: passport, military ID, driver's license, social security card, and all of that. I said I'm going to give them back that and see what happens, because all is retained that is not surrendered or rendered, and we don't surrender. We don't need to do that because we've already won. So I said I'm going to give them back all of that, and I'll use nothing but moorishe documents to do the things that I do. because I wasn't using those documents anyway. So this is one of the documents, and let me just tell you the outcome before you decide to do that. I want to show you the outcome of that, what happened. I did a probate render of fraudulent war documents, debt, personal effects, and the person. I gave them back their person. Okay. I did it by court action, and I said, with this affidavit, this living state does hereby render the following properly identified dead person to the King County Superior Court and the King County Coroner. Richie, Pauline Denise, and all agents, principals, heirs, assigns, and any derivatives thereof. Said person is a lien and is debt or dead. Said debt is not transferable and remains with the issuing dead state, which was them, according to the law as stated in Luke 9:60. And you can look up Luke, the 9th chapter, verse 60. It says, Yeshua said unto them, let the dead bury their dead, but go thou and preach the kingdom of God. We're God. So it says, all derivative debt is hereby rightfully rendered to the United States Corporation Company. This court exercises the right to forward any and all evidence of debt at this time and at all points in time. And then I quoted Luke 9:60, and I also quoted 31 U.S.C. 3128, proof of death to support payment. It says, a death finding proclaimed by an office, official, or agency for the United States government, authorized, and that's government with a small g, and it's not in black, it's not a dead one, it's a living one, authorized by law to make the finding, is sufficient proof of death to allow credit in the accounts of a Federal Reserve Bank or accountable official for the Treasury in a case involving the transfer, exchange, reissue, redemption, or payment of obligations of the government, including obligations guaranteed by the government for which the Treasury is the transfer office. And then I quoted the Treaty for Peace and Friendship, 1786 and 1836, Article 22. It says, if an American citizen shall die in our country and no will shall appear, the consul shall take possession of his effects, and if there shall be no consul, the effects shall be deposited in the hands of a person worthy of trust, until the party shall appear who has a right to demand them. But when the heir or the fiduciary, and I put the words fiduciary in there, for the person deceased be present, the property shall be delivered to him without interruption. When a will shall appear, the property shall descend agreeable to that will, as soon as the consul shall declare the validity thereof. So the will of the person doesn't speak, the consul speaks. The fiduciary speaks, okay? We speak for the natural living persons in all capital letters. We speak for them. They don't speak. We do. And then it says here, United States Charter, Chapter 12, Article 84. It says, it shall be the duty of the ministering authority to ensure that the trust territory shall maintain international peace and security. That means no war on our land. And this is the living United Nations Charter, not the dead one. It says the ministering authority may make use of volunteer forces, facilities, and assistance from the trust territory. Now that's what City of Federal Way is, who issue the do not detain. Okay? It says the ministering authority, because we're the ministering authority, shall make use of volunteer forces, facilities, and assistance from the trust territory in carrying out the obligations, not debt, but obligations, towards the Security Council overtaken in this regard by the ministering authority, as well as for local defense and the maintenance of law and order within the trust territory. Whereas, and more, this is powerful right here, because it says we have the authority to do exactly what we're doing. Okay? We have the authority to create documentation and set ourselves free. So that we are not in fear. Okay? Now, it says, whereas this writ for entry and all attached documents are hereby handed down for further custodial enforcement and notification to the following offices and all office agents, principals, heirs, assigns, and any and all derivatives thereof. And then I listed some offices. The United States Court, Chief District Judge, Clerk, Office for the King County Sheriff, Office of the Mayor of the City of Federal Way, which is, I'm the mayor, but that's an office. Police Chief, Federal Way, Governor, Washington, that's us. Okay? And because that's us, we have the authority again to do all the things that we're doing. It says this writ for entry is also the arrest warrant for all who unlawfully occupy the above named offices. And then I listed some things about the property down the street that we have proclaimed, and you can screenshot that. I won't read through all of that, okay? But it's just talking about the property. And then Job, the 32nd chapter, verse 21 and 22 of the King James Version says, I shall not accept any man's person, neither shall I give flattering titles unto man. So it's against the law to even call them judges. It says, for I know not to give flattering titles. And then I put this part because we're the ancient Sibyls. It says, I am my maker, therefore none shall take me away. All dead titles are hereby cast into the sea into perpetuity. Matthew, the 21st chapter, verse 3, no one will question you, for the Lord has need of them, and he shall send them right away. Okay. Matthew, the 22nd chapter, verses 16, 21, and 22. And again, Moors, the Bible is a legal code book. When they see these things, they cannot do whatever they want to do. They have to do what's being told here. Okay. It says, and they sent out unto him their disciples with the Herodians, saying, Master, we know that thou art true and teachest the way of God in truth. Neither carest thou for any man, for thou regardest not the person of men. That means no one else is even supposed to. They're not talking about you. They're not talking to you when they start talking about a person doing something and saying something, and a person has to appear in court. If you and your court didn't do it, that's not you. That's their person, not your person. And they know this because they read the Bible. Verse 21 says, they say unto him, Caesar's. Then saith he unto them, render therefore unto Caesar the things which are Caesar's, and unto God the things that are God's. And then verse 22 says, when they heard these things, they marveled, and they left him and went their way. They went their way. Not our way. They left him alone. Okay. And then I quoted a bunch of other things that talk about who we are and the real Pauline Denise Ritchie versus a dead fake one. And then I put some exhibits here. The birth certificate that they created, front and back. The Social Security card that they created, front and back. Now you'll see here, at one point I signed it in red and put my right red thumbprint, but then I redacted that because I said, wait a minute, we need to be doing our own. Okay. So I did my own. I sent my own sovereign security number document with this court action. And then the driver's license front and back, the passport, military IDs, veterans IDs, military spouse IDs, all of that was enclosed. Wedding certificate, bills, anything that they produced. I put it in an envelope with this affidavit. And I sent it to them. I actually hand carried it. And then I also sent with it proof of some of the documents that we sent forth previously. Okay, proof of delivery of those documents to the places where we sent them. Okay. So now, once I did this, let me show you what the response was. Because what this is that I was doing was I was stating proof of claim. That's what this is. It's a probate render. That means somebody is bankrupt and the creditor is stepping forward saying, okay, we're going to take control of all of the resources on the land. Okay. And I got a response back. And again, they couldn't respond directly to us because we're the living. So they did it in a custodial manner. Let me show you what that was. Let me show you what was sent back. Now, remember, Morris, what we're doing is proof of claim. They have to have a response to the proof of claim, okay, based on what's in these bankruptcy laws. Okay, so once a proof of claim is filed, we've shown this proof of claim form, but we don't use their forms. We just looked at the form, and then we put what needed to be put on there, okay, in terms of us being the creditor. And so let's look at Rule 3004. Not 3004 actually, because we're the creditor. We quoted Rule 3003, I believe it is. Let's see. Up 3001. Proof of claim. This is so important, Morris, because whenever they were claiming that we were minors and then going about doing things and saying that they're the creditor, they were pretending to use this right here. It says here, who may execute? Form and content. A proof of claim is a written statement setting forth a creditor's claim. That tells you it's not a form. They're telling you that. It says a proof of claim shall conform substantially to the appropriate official form. All they're saying is look at the form and then do a written statement about that. And further in here, it talks about affidavits being what needs to be done. So that is why we say what we say and do what we do, Morris, is we cannot we'll get to that because, again, you got to think about who's sending the statement. So proof of claim, it must be done in written format, And because you're the government, only governments can claim to be creditors. That's another something that we see here. It says, who may execute? A proof of claim shall be executed by the creditor. It says, or the creditor's authorized agent, except as provided for in Rules 3004 and 3005. In other words, 3004 and 3005 talk about the debtor. Debtors cannot execute anything and cannot be authorized creditors. Okay? We just looked at that. A proof of claim shall be executed by the creditor. And then when it comes to the sleeping Moors, that's why we say all Moors, because we're providing coverage for them while they sleep. And then when they wake up, they're going to have to stand and be themselves. They can't receive of the estate in that status as full creditors. They actually have to stand up and claim who they really are. So it says here, supporting information, claim based on a writing, not a form, but a writing. It says, except for a claim governed by paragraph 3 of this subdivision, when a claim or an interest in property of the debtor securing the claim is based on a writing, a copy of the writing shall be filed with the proof of claim. If the writing has been lost or destroyed, a statement of the circumstances of the loss or destruction shall be filed with the claim. So again, they're saying here that the property, that debtors have property, but in our system, debtors don't have property. Debtors don't own anything. That's what liquidation is saying. It's saying debtors, you don't own anything. So here it's talking about amounts necessary to cure any default and all of that. We'll get into that as these proceedings continue. Because the amount is an unlimited amount, but again, we started with 100 million for each event. Okay. It says if a security interest is claimed in property that is the debtor's principal residence, the attachment prescribed by the appropriate official form shall be filed with the proof of claim. And this is talking about titles to the property, deeds, and all of that. Those are security interests. Okay, but again, we already have placed on the public record that we are the heirs to all land, all natural resources, and all commerce. We've placed patents on the public record. We've placed titles on the public record. All of that is already out there on the public record and is connected to these documentations that we put in as proof of claim. So we did the proof of claim, and then we again looked at, okay, it should be in written form, it has to be, and then we started looking at the what ifs and therefores and all of that. And the majority of this that you see here does not even, we've already covered these bases. By simply, our nationality covers the majority of this. Because in this, they start talking about the difference between a holder. One minute they'll say it's a holder, the next minute it's a debtor, the next minute it's a security interest, and so on and so forth. Our sovereign status covers the majority of this, and because our courts are ministering this and we're notifying lower courts, a lot of this is not even necessary for us to read and go through. Okay, or no, we must read it, but you'll see as you read it that it's not even necessary. Okay. With regard to, for example, domiciles that have been where an unlawful foreclosure happened, that property is not lost. Why is it not lost? Because it's still where it was before. It has not changed. The only thing about it is it's not in a false jurisdiction, it's on the land, and that must be stated. See, loss at sea is a term that was used because we had not put competent constitutions and charters on the public record and said, this is where everything is. We kept using their constitution and pointing to their stuff and saying, it's there. We have addresses in our constitution, our commercial constitutions, our state constitutions that we put on the public record, and we say all custodians and subjects and servants follow this. This is where everything is. We put the Washington Constitution on the public record. Washington is Washington. It's not the corporate state of Washington as put on the public record by fakes and frauds. Okay. So now, we see some things in the chat. We're going to cover, if we don't cover it in what we're saying, then provide that statement or question later in this process. So let me show you. So we provided proof of claim, and we sent all of that stuff back to them. So what did they do? They sent the stuff back to us. Okay. And let me just show you what that looks like. We have one of them open. I want to show you first the envelope that it came in. We want to show you the envelope that it came in, because even the envelope that it came in provides a lot of information for us. Okay, first of all, they're paying postage. They paid $3 and some change, or in their script. Postage. That means that that's not a government, because the government doesn't pay postage. When we send our documents out, we don't pay postage. And you all have seen the postage demonstration that we did. We put in a video up showing Moors how to do that, how to do their mailing so that they don't have to pay fiat in order to mail your documents out. Okay. And then they said United States Court Fiduciary. And they put theirs in capitis diminutio minima and put this in capitis diminutio maxima. So we still have to, again, keep our eyes on the resource, because we're the King County Superior Court in red and all lowercase letters. Okay. But there's a difference, because they are making a difference in the jurisdictions. They're saying this is different. Okay. So now, we are the United States Court Fiduciary, but we're not their United States Court Fiduciary. We are our United States Court Fiduciary. But I just wanted to show you this part, and this is what was in the envelope. All of the documentation that I sent stating the fraud was in there, and then this was in there also. They, according to bankruptcy law, see, they know bankruptcy law. According to bankruptcy law, whenever a proof of claim is made, they have to do like an inventory, and really they're just showing us how to do it. We inventoried the documents that we sent, and then it says here they put this information here, and again, this is not me. This is their creation. Okay. It says 911 Southeast 314th Place. I don't even know where that is, because we're at the ancient 911 Southwest 314th Place. But it says here, documents and identification delivered to the King County Superior Courthouse. Dear Miss Moore, an envelope was delivered to the judge's mailroom on July 1st, 2022 at 4:01 p.m. The judge's mailroom. I'm a judge. That's why I use that mailroom. And when I say that mailroom, it's the mailroom that I say it is. It says the contents of the envelope are as follows. And then they went about listing everything that was in there in exhibit form. Everything that I sent. Military ID, veterans cards, driver's license, social security card, rendering unto Caesar that which is Caesar's. Okay? So they said, okay, we got this in here. We're looking through, we're noting each and everything for the record. It says here that the court did not receive copies of Exhibits G and H6. In other words, they're saying we received all this other stuff, we just inventoried all this other stuff, but we did not receive Exhibits G and H6, which they did. Okay, and then it says the court does not accept receipt of the envelope or its contents and it is being returned to you. They received it. They do not accept receipt of the envelope or its contents and it is being returned to their, whoever they say it's being returned to. And then they signed it here. So now what are they really saying here? Because we know they received it. Even though this says they didn't, and they don't accept receipt of it, we know they received it. So what are they really saying? They know that the word accept is a financial term. Okay? Yeah, yes, in the chat. Is that why they created the United States Postal Service, so that they'd have a mailing system that would accept fiat? Yes, that is why that was created. And it was a commercial overlay of the post office. The post office accepts real money. Yes. So what they were really doing is a court action inventorying, and they're not a real court. Let's make that clear. This is not a real judge. I'm the judge. This is a subject. And that's why this is not even real letterhead if you look at it. Because when a judge speaks, judges use seals, don't they? So this is a subject, but we have to know that stuff. We have to know that a real judge will stamp and seal what they do. Okay? So this is, what this is really saying is that acceptance is a financial term. A financial term means, are you financially responsible? Well, they don't have anything. They don't have anything. So they can't be financially responsible. They don't really even exist, to be honest with you. We're the fiduciaries, okay? So we're the ones that have the financial ability to accept, reject, deny, etc. Now, earlier in this call, we read one of the codes. I believe it's this one right here, 3001 proof of claim. And in this code, it stated, I believe it's this one where it stated that a clerk does not have the right to refuse the documents. Okay, we read that in one of these codes. Okay, so we know that there's no refusal of the documents. They're trying to tell us something else here. What they're saying is they acknowledge the documents because they inventoried them. That's acknowledgement. Okay, acknowledgement of the documents, but they don't have the authority to do anything about it. Why? Because they're not the fiduciaries. We are. So they acknowledge them, but they can't do anything about it. So what they're saying is, we're passing, we've been neutered. We've been muted. We can't do anything about these documents. You have to do it. And that is what we're doing. Okay? So then when they sent everything back, what does that mean? That means that at any time forward, because see, whenever they take things in, they actually have to put it on the public record too. Okay? Yes, it was 5,005. Thank you, Nobility. 5,005. They can't refuse it, and they didn't refuse it. They inventoried it. They didn't mark refused on the envelope. I got the envelope back. They put the envelope in there that I sent it, that I gave, when I delivered it, doing sovereign postmaster duties. They can't reject it and they can't refuse it. So they're saying we don't accept receipt of the envelope. They don't accept receipt. Accepting receipt is a financial term. Those are financial actions, acceptance and receipt of it. Okay? So what do we do now? We can take all of these, all of our actual documents, the driver's license and all of that stuff. We can do whatever we want to do with that now in terms of getting whatever it is that we want to get from our estate. We can do that because they have actually rejected, not rejected because they can't reject any of the things we do. They're saying financially we can't do anything with these. That means that financially we can do something with them if we choose to. Okay? But we wanted them to do what they're doing, what they did, which is know that we know these documents are fraud. The documents were fraud. So now we can do whatever we're going to do in terms of authentication and all of that, because see, they cannot authenticate documents. We have to authenticate documents. And that's if we want to authenticate them. We don't have to access our estate. We don't even need their documents to access our estate at all. But this is something that we can take, and then we can say, okay, King County Superior Court, we can put on the record whatever we want to put on the record coming from King County Superior Court with regard to these documents. Anyone claiming that there's a debt owed and they try and use these documents to say there's a debt, we can say no, there's no debt. There's no debt. Based on on this notice right here, there is no debt associated with us and our fiduciary capacity where documents are concerned, because they have not accepted receipt of them. Those are financial terms. They don't have anything to give, to pay. So when Morris kept looking at them and saying, y'all need to pay, they need to pay taxes, they need to pay this, they don't have anything to pay with. This is proof that they don't have anything to pay with, because they can't even, they can accept, they see that the documents are there, cannot accept receipt of the envelope. They don't have anything to pay with. So now we can take those documents and do whatever we need to do, such as these types of documents right here. What we're saying is, okay, everyone's bankrupt, therefore all of you are resigned. You have nothing to do with what's going on in this estate. And then for those subjects who need it, we can give the subjects these things right here, so that the record is clear, and so that fraudulent policy enforcers and all of that, they're muted and bound. They're cast into the sea. They have nothing to do with us. Okay? Now, if subjects want to protect the Moors, which we don't even need that, because they were the only ones violating And that's because we thought we were citizens. But now that we know, again, more, this is providing protection and remedy for ourselves. We can do things like this. Okay. Now, someone put in the chat that they don't have these documents anywhere. They got rid of all of the driver's license and all of that stuff. If you don't have those documents, you don't need them. All you need to do is begin, first, state your proper status on the public record. That's number one. Number two, please terminate all corporate contracts and don't do any new contracts with them. Please don't do that, because that is them accepting receipt and saying, okay, we can use these to bill and send debt. Then they start trying to put debt everywhere and saying, well, we have a contract with you. Here's your signature on the contract. You've not given us proof of claim that you're the creditor. So for the Moors who don't have those driver's license and all that stuff, that's fine. Do your affidavit. If you ever had those documents, whatever the number is, and it's not hard to find those numbers, whatever that number is, lien it. Lien, and here's the thing, when you lien the nom de jure and the social, it's going to cover all this other stuff. It's going to cover all of that. So your proof of claim can have the nom de jure and the social on it in terms of what you're rebutting. You rebut those. Okay? Rebut them and say that they're dead, because they are. They were issued by a dead entity. Okay? Now, and also they know that this is so funny, because nothing that they issue is valid with regard to us. We just have to know that. Yes, this letter is here, but it's not valid until we say it's valid. And it's only valid for the reasons we say it's valid. They can't use this to say, oh, she said she's the other Pauline, the dead one, not the, no, they can't do that. They're not even court. We have the authority to say what this means. Okay? And the fact that they inventoried it says that all of this is deactivated with regard to debtors. Deactivated. See, acknowledgement of the affidavit is acknowledgement of the truth in the affidavit. Okay? This is not even a proper rebuttal. If they were going to say, oh, they rebutted her affidavit. No, they can't. You gotta get past that flag first. Where's the rebuttal to the flag? Where's the rebuttal to the seal? That's why we seal. Where's the rebuttal to the right red thumbprint? So they weren't even trying to rebut what we sent. They weren't even trying. That's not the purpose of this. The purpose is to say, yeah, we got that stuff, but we can't do anything about it because we don't have any money. But this right here, Morris, is a receipt also. This is a receipt. I could put this with my lien on the nom de jure and the social, and I can say, okay, this is monetizable. They've already said that they don't have any money, so monetize it in delarium dollars. We do that. They can't do it. And that's why we're looking at bankruptcy in the manner that we're looking at bankruptcy. Okay. So what we have shown you here is that proof of claim, and more, again, you don't necessarily have to even package up everything and send it back to them. When we do our documentation, we do it in the favor of all Moors. But for the Moors who want to do this, I would encourage you to do it. Make copies of it so that if you need to show a copy of it for your purposes, or you want to have it for your purposes, that's fine. But nobody, even when you travel, no one has the authority to ask you for anything other than lawful documentation. And that's why we send all of this stuff ahead. And we say that the custodian that was previously in the office of the FAA says that we're coming through on this date and this date, and that there is to be no obstruction whatsoever to us coming through with our ID, etc., etc., etc. And see, we're planning on doing some travel sometime soon. And when we do the travel that we're doing, we're going to be using our processes. We're going to have a letter from the FAA. We're going to have a letter from the heads of the custodian, the heads of the airlines, because we're the heads of all airlines. All of that stuff is going to be sent out beforehand. Okay. All of that, stating that we are who we are and that we're doing what we're doing. Okay. So, Moors, we're liquidating. This is proper liquidation. State that you're not a debtor. And that's what this is. This is just saying, hey, I'm not your debtor. You're the debtor, not me. And they're admitting here that the court does not accept receipt of the envelope. They're not even a real court, so how can they accept receipt? I'm King County Superior Court, not them. I have accepted receipt of that which is mine, which is my vast estate. So now we can take this document right here and say, okay, whatever we need to get, we can get it. And we're not going to use fiat. Okay. We're going to continue moving forward with the bankruptcy. There's a section in the bankruptcy procedures that talks about liquidation. We'll be going over that section next week. Let's see, today's Thursday. We'll be going over that on Sunday at 6 p.m. Eastern. Now that we have established that proof of claim, you know, and I've established it just to show you how to do it, how to establish proof of claim. We just needed that to know that, and we didn't need to because we knew it already, but we wanted to provide proof of claim properly by way of the fraudulent documentation. And more, if you don't want to send the stuff to a court, just put it on a public record and say this is fraud. That's this passport, this driver's license, this social security card, and all of this driver, you know, all of that. Just put it on the public record, and the debt that goes with it, because I put some debt there too. There was a couple of student loan things, U.S. Department of Education. Well, I'm the CEO of the U.S. Department of Education, and they're in liquidation. So how do I have a debt? I don't have a debt. And again, this, by them saying they don't accept receipt of the envelope, and they're not a court, but not accepting receipt means we can't do anything about this. We don't have the money to do anything about this. Okay, we knew that when we sent it. We knew that. We just wanted it on the public record that we are not a debtor or a co-debtor, because as I was looking through the bankruptcy information, it talked about co-debtors. And I'm like, okay, let's make sure that that it is clear that we are not co-debtors either. Okay. Are there any questions or comments? I'm going to open up the meeting, the table, as soon as I can get to that part. Let's see. Okay, here we go. Okay. Oh, let's see. Just one moment. Let me get to the button. Just one moment. So the process, Moors, of proof of claim is simply stating by affidavit in written form, by affidavit, who you are and that you're not the debtor, you're the creditor, and then knowing how to look at this information on bankruptcy. And Moors, yours doesn't have to look exactly like mine for it to be valid, because it's our court, your court, that is actually determining what's valid and what's not. And we're placing on the public record today that the sincere energy that is put forth by who are peaceful, because it can't be war energy, please, who are peaceful, we accept all documentation. All documentation. Our court does, and we have to accept it first in order for it to be accepted, in order for it to be, and again, when I say we, I mean all of us. You have to accept your own documentation. You must accept your own documentation. Okay? Justice Consul, are you okay? Are there any questions or comments? You can star 6.
Islam.
Islam. Okay.
I'm loving this. It's 3 o'clock in the morning here, but I'm loving this.
Oh, I'm sorry that we're keeping you up.
That's okay. That's okay. I love it.
Yeah, Islam. So, did you have a question, Nobility? Thank you for staying up with us too, by the way.
No, at this point.
Okay.
Islam.
Islam. So, Morris, any other questions or comments with regard to what we have put forth thus far?
Islam. I'm sorry. Go ahead. Can you hear me?
Yes, we can hear you, Empress.
I have bad reception today. My question is, a lot of us are filing 1099s with the corporation, and we're doing all this work. Does it somehow keep a contract with them on this land? It seems like we'd be chasing our tail if half of us are doing this work and the other half are still contracting with them. I'm just trying to figure out how's this going to work. Islam.
Islam, that's a good question, Empress. So the way this works is this. Everything that's being done, it never had anything to do with foreigners. We are all sides of this earth. What do I mean by that? I mean that those that you were filing 1099s and saying you need to report this or that, at the end of the day, it's going to be more sitting in those seats, accepting your 1099. We're the head of all corporations and companies. So when you do a 1099 and you say you give it to the custodians in the office of judge, all they're really doing, because they know who we are and they know that what we're saying is true, is they're going to take that 1099 and they're going to say, okay, the Moors have accepted their ascension to the stewards of all. So here, let's pass this to them because they'll know what to do with it. This was never about foreigners. It was never about them. This was always about Moors. So all of the liens that we have filed, yes, they're valid. They went on the public record and all of that. From this point forward, everything that we put forth, there's going to be, and you can see it, you can already see it. Wherever you go, you're going to see Moors that are the heads of everything. Moors at the gate keeping, receiving the documentation. They don't, when I go places and I say, can you get someone here to assist? They never send a hybrid, a modern European. They always send a Moor. And it's generally a sleeping Moor. But this is, all that you're doing is valid. It must be done. You're letting the Moors that are in those positions know that there's another status out there that they need to know about. We're letting everyone know that, okay, we're prepared to start taking the proofs of claim from the heirs. But as we take the proofs of claim from the heirs, we're not going to access a system with some fraudulent forms in it. It's going to be affidavits and written, because a computer bot can do a form. So there's no way to tell if the form is real or fake. A computer bot can do that. So all of the documentations and things that you're doing, it's necessary to do them so that you can get the credit, but it's going to be other Moors that are going to be giving the credit. So that the estate is governed on all ends by us. That's what's happening now, is the closing in is coming, where we meet other Moors in the middle. We're meeting the corporate Moors in the middle, the ones that haven't awakened to who they are, but they have these jobs and they're doing things. Because as people start going back to work, it's not going back to work. It's going forward to the Moors' vast estate, and the Moors are the head of everything. So the 1099s that you're filing, they need to be filed. But just know that it's going to be Moors on the other end receiving them. And right now what we're doing is we're saying, Moors, don't do it this way because we can't receive it this way. Do it this way. So 1099s by affidavit is the better way to do it.
Islam.
The
document you found that was from a Moorish site. Can you go over that again with the focus on the locations that you had read? And then do you know the importance of those locations that was on there?
Those locations was when they were setting up, all they were doing was tying themselves to the fraudulent Federal Reserve banks in those territories. That's what those places, St. Louis, we know there's a Federal Reserve there, New York, Philadelphia. And Philadelphia, they were really just tying themselves to the Moors with that Philadelphia piece. So when you know our history, you will, if you think back, Empress, because you know our history. We talk, you know our history. Then you know that those places that are listed on there is places where they were saying, okay, they put Florida in there because Florida was our capital also. The land of flowers is where the Alhambra is. That's the real Alhambra. The one that they show on the internet is not the real one. The real one is in Florida. It's at Florida territory. So and that's where we were doing all that we were doing before Philadelphia came into play. Before Philadelphia. And then before the Alhambra, or in connection with the Alhambra, was ancient Washington District for Queen Columbia, which is this place. So when you look at our past, it will tell you why they chose those places to do things, because that's where the capitalism had to be implemented, and the hypothecation was implemented in those places. The capitalism specifically. New York, 55 Water Street in New York is where the fraud took place financially. Once they had gotten all that capitalism done, it all started at New York, where finance is concerned, and then where status is concerned, it started at Chicago, Illinois territory. So there's 7 mountains of government. They did what they did corporately where their 7 mountains were.
Islam, because I remember researching and reading about when they created the whole bar association. They went to Saratoga, New York, and they had their meeting, and they invited several, corporate states, but then they made a special mention to have invited District of Columbia. And so, yes.
That was them handing over the names, quote unquote. And we all we really needed to do was rebut that, which is what we're doing now.
Mm-hmm.
And then put it on the public record that we know. And then make sure that we address the 7 mountains of government. Commerce is one of them. That's what New York is about. And the Bar Association ain't nothing but commerce.
That's facts. Islam.
And then D.C. had to do with a hypothecation of what of the residency, and the saying that that's where they were saying that they made it look like all land was being governed by D.C., but it wasn't. All res idents that spread out over our land were governed by D.C. So it was the persons that D.C. was governing, not the people, the persons, the all caps names. And then all they did was send out a whole bunch of persons, foreign persons. And that includes corporations too. They are foreign persons that were sent out to fraudulently claim a territory when the land ain't got nothing to do with them. So they said, okay, well, we'll just be the state of Washington since we can't be Washington. Or we'll be the state of Illinois since we can't be Illinois. Because we can't govern over the Moors like that. We can't say we're the same as them. But as fiduciaries, we can. Yes, Justice Morpheus said the overlay, extraterritorial. That is exactly what extraterritorial means in its proper, not proper. Well, there's a place for that too. But extraterritorial means you're in the same territory, but you done added something extra to it.
Extraterrestrial too.
Yes. Because what is terrestrial? That's the land. Terra means land. That's where the word territory comes from. So that's called the Buck Act. The Buck Act is where they made a name that sounded just like it, but they changed it just a little bit. So they clone it, and a clone can never be exactly like the original. There's always going to be something about a clone, even when they're cloning animals and plants and things like that. The creator of the plant, the God, will always know the real from the fake, even though clones seem like they look just alike. Because we know that the real one comes from a real living source. And the clone will not be doing what the real does. Our clones went out there and got drunk and high and did all types of craziness, but the real living heirs never did any of that because we didn't know we weren't that until now. Now when we, have a sip of wine, we do it with full disclosure, knowing what will happen if we imbibe too much, et cetera, et cetera. And we know that pharmaceuticals are for healing, but food is the first healer. Nobility, did you have a question?
Yes, since you mentioned extraterrestrial.
Yes.
Similar, I know terra means earth or land. But what about terrorists?
Yes. Oh, that's so good. That's so good. When they call us terrorists, when they were saying that, they weren't talking about us. They were talking about them. Okay, because we're not that terrorist. We're the other terrorist.
Okay. So.
Yes. See, that's why ancient English is so important. Because in ancient English, you can write, I am a terrorist. And you spell it differently because you're going to put an A in terrorist, where they have an I in terrorist, or an O rather. Okay? And you cannot be accosted and put in jail for saying you are a terrorist. That's why I'm saying we don't speak the same English. Their language is a dead language because it was killed in battle. And we're at peace. We're not at war with anybody. So we speak ancient English and we say whatever we want to say, and it still means peace. That's why ancient English is so important, because I know there have been some Moors, even some Moors very close to us, that were trying to say ancient English is not. But I said, you know what? All languages were made up at one point. So who had the authority to do that? We do. And we're not even really making it up. When you look at the spelling and then you go back and look at ancient French or Old English, that the ones that the custodians in the office of Queen had their version of English called the Queen's English. Oh, they get to do it, but you can't do it?
Shakespearean as well.
Yes. Come on now. But we had some Moors sitting real close that was saying, that's not a language. Oh, yes, it is. Yes, it is. It is. It is because we said it.
Islam, and the further you dig, the more you'll see the evidence of that was, because remember the charter New York that I shared with you, it's full, cram-chucked with ancient English.
Yes, and when you look in the Library of Congress, you can see some of those documents that they have not really wanted to put out there. Ancient English all over the place.
And at one time, Ebonics was widely accepted. And they were getting ready to push that. But somebody stopped them and said, you don't want to do that. But they was all on the TV with that. They was going to embrace the language.
Yes. But that's because that didn't start with us, though. They were trying to claim what we say that they didn't teach us.
Yeah.
Because Ebonics, they didn't teach us that. That's something that came out of us naturally. Because we have, see, what we did not realize when we were using Ebonics is that we have ancient languages that are encoded in us, in ourselves. And that's what makes us pronounce something totally differently from the way that we were taught in the education camps.
Yes.
We have ancient languages that's not going to leave us. It's going to stay with us.
And for the most part, they didn't have a problem with it. They were about to implement it. But somebody said, you don't want to do that. But so now they make sure that if you come up with a language, it's frowned upon. But they condition our minds to do that, you know. But initially, when I saw, I was kind of floored. I know I was young, and they were on TV talking about
Yes. I remember that. They had a dictionary and everything, didn't they?
Yes, they did.
I was like, wow. And and the same ones that's talking about ancient English ain't a language, I guarantee you they probably was going to buy one of those dictionaries, those Ebonics dictionaries. Anyway, go ahead, Empress, I yield.
Okay, yeah, great. Islam?
Islam.
Yes, before I found this consulate, I used to take lessons of demonstrations from a hybrid who was teaching ancient English. So when it came to our consulate, I wasn't a stranger to it. And so there's literature out there. If you really want to look around and learn more about it, you're right. This is ancient, and it's not something new or made up. So I was really happy for us to receive it because it freed me. Because when I would write the language, it was frustrating because like for some words did not match the actual letters, and they would drive me even bananas. Right. So anyway, thanks for listening, but it's out there if you really want to know. Yes. If you really want to dig into it, that information is out there. Look around even on YouTube. I don't want to say his name, but I followed him for a long time. Anyway, he also used the Styles Dictionary. So just want to share that.
You know, Empress, I had not heard of anybody calling it ancient English. I just know that what the ancestors told me about corporate English. And I started reading up and looking at the writing style manuals. The U.S. Writing Style Manual is a manual that law schools use. And then I started looking in the dictionaries, the older dictionaries, and whenever I would look in the older dictionaries, they would have the Latin spelling of the word, and it would be spelled the way we spell it with ancient English, but then they would have the other spelling, which is to me inferior. You know, when you look up, for example, if you look up the word already in the dictionary, already, you know, like you say, we're already there or we're already done. They would divide the word in two and spell it differently, and then define it.
Also, if you read the VK Trust, it's written in ancient English.
Yes, it is. Empress, let me tell you something. The ancestors told me about ancient English, and that came straight from them, and we took a lot of heat for that. I'll just tell you, we took a lot of heat for that. But then when I look back at Sesta QV Trust, the ancestors led me to the legislative records in the UK. And I got to see the entire document. I was like, this looks like I wrote it. It looked like I wrote it in ancient English. I said, if I didn't know any better, I would think I wrote that because of the spellings. And that's what they've been using. Cesta QV, that was what they were using to do what they were doing. And we needed to rebut that. But when the ancestors told me about ancient English, it came straight from the spirit. I didn't see anything in writing about ancient English. But then the ancestors started showing us about what they call parse syntax and all of that, and how they, you know, they started talking about parse syntax, and I'm like, okay, I know they didn't invent anything, so let me just look at this for a minute. Because they didn't invent anything. They didn't come up with anything. That's not any of their doing. That's ancient, what they're hypothecating. Okay? Because you can tell they're reading it from somewhere. But they don't ever tell you the source of what they're reading. So I looked at it and I listened to what they were saying about the rules of grammar. And the ancestors said, now, they're going to, see, the rules of grammar that they were using, they have to change the word allodial and only put one L so that it won't mean the same thing as our allodial. Because our allodial is the real allodial. When you put two L's on allodial, A-L-L allodial, that means no contract with the dead. If any word that starts with a vowel and two consonants, that means no contract, like affidavit. Well, then I said, okay, well, what about the word application? Because people fill out applications like job applications and things like that. Doesn't that mean no contract? It does if you created the application. It does if you create the application. If you use their form and they call it an application, that means that you're contracting with them and they're not contracting with the Constitution. Some may want to disagree with me on that, but you know what? Every last one of us has had a job and they charged us taxes and was fighting about not wanting to do right and all of that. That's why a lot of us had to come out of that system. And really all of us had to come out of it. Because when we started asserting our sovereign status, there was pushback. Well, there's not pushback now. There's not pushback now. We had work to do, and we still have more work to do. We're never going to stop governing, but we see now that the workplace has changed tremendously since we started demonstrating. Has it not, Morris? Since you started demonstrating, the workplace is a different place today than it was when you first started, isn't it? We can look at the YouTube and see that it's different. We can look at the way things are being done and see that it's different. So, yeah. We got this. It's a wrap. And let me just say that what we were doing before when we were asleep and we thought that we were citizens and all of that, that was an experiment. They call it the quote-unquote American experiment. It's over. It's over. Over. Everybody back in their places. Places, everyone. You know how they start a play, and they're directing a play, and someone claps, and they say, "Places, everyone." The director says, "Places, everyone." Okay, places, everyone. Rightful places. Because they were just acting, and we were acting too. Acting like citizens and res idents and servants to corporations instead of servants to ourselves and our heirs. Yes, Islam. Islam in the chat. So with that being said, we are going to adjourn here. Again, those who are you may or may not feel like you've done proof of claim. If you want to do proof of claim with a surety, when I say surety, in other words, knowing that you are who you are and that you've done it competently, just send your name change and judicial proclamation and a termination of all corporate contracts and a fiduciary document, those 6 documents that we talk about. There's a little bit of, Aisha, there's a little bit of, just a little bit coming from your line. Let me say this, and then if you have a question or a comment, we will be honored that if you would let us know. For those who want to put proof of claim to ensure that you've claimed who you really are, the 6 documents, name change and judicial proclamation, a termination of all corporate contracts, a proclamation of trust, a lien on the nom de jure and the social security number, and a lien on the United States Corporation Company and the fiduciary document. Those 6 documents will be proof of claim, and then what you do is put it on the public record, and then also just send it, or you can deliver it and just put it on the counter to any quote-unquote court. It can be municipal, it can be claiming to be county court, it doesn't matter. They're all subject. So just deliver it to them and reserve your questions for when you get home and you want to look it up. In other words, you don't have to ask a bunch of questions about, hey, what do y'all do with this document right here? Because they're automatically going to try and usurp because you don't know what you did. That's why we say demonstrate at the level of your understanding. When you send the documentation, know that what you're doing is proof of claim. That doesn't require a discussion from them. I can't tell sovereigns what to do, but it don't require no subject to speak. And we're not pushing on subjects and bullying subjects. We're not doing that. But what we're saying is more is you have to know what you're doing and know that your proof of claim is that's not rebuttable. They don't have the money to do anything about your claim. Know that. That's why we're doing it. And the way that liquidation happens is the way that we've shown you tonight, where you can take whatever issue you have going on, whether it be someone trying to say you have a mortgage. Well, no, what you do is you liquidate by going and sending a letter from the CEO, which is you, with the signature of the custodian, the former custodian of the mortgage company, stating that you do not have a mortgage, that you do not, you're the tax assessor, you don't have taxes either, you're liquidating. And a resignation letter of whoever it was that was claiming to have that office. Fiduciaries, it's your obligation to handle that debt that way. And we do that first, then we can go out and talk about conveyances and domiciles, new domiciles and all of that. Groceries and all of that can be liquidated the same way. All of it. Now, one last thing that I wanted to show you that I came across today while I was doing this study. It's about discharge.
Islam Empress, while you look for that, I just came up with another way of making it simpler for people who may not understand about what you were speaking about, the receipt and how they couldn't do anything with it. Yeah. So let's say we all know when we worked at a job, they had, what was it called, like a place where, like, if you needed money and they would go into what was it called? Something where they would have, what is it called? For, oh, you know what I'm talking about? The petty cash, thank you, petty cash, right? And they would give you petty cash from their petty cash account, right? But you'd have to bring back a receipt, proof that you bought something for within reason, with, you know, within their rules and regulations, right? And then you would have to fill out an expense report. And sometimes if you spent over that what they gave you, they would give you back the money to cover your own expenses and accounts and such. But so what I'm getting at is when Light gave them their, you know, their stuff back, and they said, well, we can't do anything with this receipt, they were saying that they weren't the fiduciary and they can't give any money because they don't have any money. They are bankrupt because, you know, when back in the day when our jobs, we would take like a gas. Okay, so if I was traveling and I paid for gas, I would give them my receipt and they would tender back the money. And so that's what Light did. She's like, okay, I had gas, I paid for gas, so now where's my money? Because it was on your dime, and now you have to give me back money. And now they're saying we don't have anything, so you have to do it yourself.
That's it. That's it. That's what that is. That's what that is. That is them saying we can't do, they're shrugging their shoulders with nothing. So we can use any resource on our land to get the things that we want to get, because we're the only ones who actually have the authority to do anything. Now, let me say something about that whole discharge piece. I went to the same website, the U.S. Courts website here. I'll put the link. This is the website that has the codes on it. And Morris, you've got to hear this with regard to that thing that they were calling, well, and we quote it, it's House Resolution 192. This is something that needed to be known about that. Here, let me put this in the chat. Okay. When you're talking about a discharge of a debt, it says, what is a discharge in bankruptcy? Now, some discharges, people were thinking they were discharging from an entity that was solvent, because there's a difference between a discharge of a solvent entity debt and a discharge of one that is insolvent. A bankruptcy discharge releases the debtor from personal liability for certain specified types of debts. In other words, the debtor is no longer legally required to pay any debts that are discharged. The discharge is a permanent order prohibiting the creditors of the debtor from taking any form of collection action on discharged debts, including legal action and communications with the debtor, such as telephone calls, letters, and personal contacts. And this is about that House Resolution 192, which is why we hardly ever saw anybody, and I've actually never seen anybody successfully use that. It says, although a debtor is not personally liable for discharged debts, a valid lien, i.e. a charge upon specific property to secure payment of a debt that has not been avoided or made unenforceable in the bankruptcy case, will remain after the bankruptcy case. Therefore, a secured creditor may enforce the lien to recover the property secured by the lien. This is on the uscourts.gov website at bankruptcy, the Federal Rules of Bankruptcy Procedure. So that House Resolution 192 piece, if they were solvent, it would be a good thing to do because they could do it. So later on, as because we're the solvent, we're solvent, okay? And we are the solvent states united. So later on, as we begin doing what we're doing, continue governing like we're governing, because that switch has already happened, okay? The switch over to us, the new, and I'm not going to say new world order because that's a term they use, new order at earth. Now that we are governing, even financially and commercially and judicially, on the land, etc., then a debt or an obligation can be discharged. Obligations can be discharged, debts cannot. Because a debtor doesn't have the authority to do so. Debtors don't own anything. And they have always known that, Morris, just so that you're aware. So the discharge process that we've spoken about is going to be necessary. But it's necessary when you're dealing with an obligation and a resource that is not insolvent. So as we do the letters of resignation, as we continue publishing the letters of resignation with the signatures on them from the CEOs and all of that, the custodians that were previously doing business, the CEO. As we continue to publish those, you will know that those resources are resources where you can do a discharge. Okay, but that's because they're solvent based on the actions of the court. And the discharge can be done, but it must be done using lawful money. You can't use fiat. Okay. Discharges, I'll just say do the study based on this link that we put in the chat. And we'll look some more into all of this. One of the questions that I had that the ancestors answered for me while as we were doing the study, I said, yes, Justice Morpheus, that's so good. He put New Earth Order is Neo, N-E-O, like Neo in the Matrix. As we conclude this call, this conference, this assembly, this gathering, this lawful coming together, this bankruptcy proceeding for today, as we adjourn for today, I'll say that any of the things, any of the processes that we put forth, now that everything is switching over to the Moors being the head of everything, okay, this is the transition of wealth that everyone's been talking about. Those processes are accepted and acceptable. We got pushback from the custodians because those processes can't be used in a debtor economy, but in a creditor one it does, okay? Solvent just means we have no debt and that we are not bankrupt. Islam. With that being said, we will adjourn here and we'll come back on Sunday at 6. Peace and grand rising to the sovereign, original, indigenous, natural, divine heirs. Islam.
Buenas noches, Moors.
Islam. Islam.
Peace and grand rising, Islam.
Peace and grand rising, Islam.
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 Islam. Islam.
Islam, sis.
Islam.
Sis.
Yes. Islam.
Before we go, I have a question. It's regarding retirement and disability. What do we do about that?
It needs to be placed in the proper jurisdiction. So you are absolutely entitled to that.
Okay.
Okay. So the steps that we have said about
right.
name change, judicial proclamation, all of that is necessary. And in the coming days and weeks, nobility, with regard to that, there's a little bit of feedback coming from somewhere. In the coming weeks, days and weeks, we're actually going to be doing a demonstration where our Veterans Administration benefits are concerned with regard to that. So we'll be showing that demonstration as well. But it needed to be put in the proper jurisdiction. That's it. And the capitalism needs to be, you need to have a fiduciary document on the public record with regard to all of your benefits. And the fiduciary document that we have published will do it.
Okay, so it's sitting through all of that, right?
Yes.
Don't file it with the forms, just send the documents. Is that correct?
Send the affidavits, yes.
The affidavits, in other words, yeah.
Yes.
Okay.
Yep.
Peace. Thank you, sis.
Islam.
Empress Light, I have a question.
Yes.
Before you go.
Islam.
Yes, Empress Light,
Speak up, sis. I can't hear.
Empress Light, I have a civil lawsuit that I incurred in 20, and in which I involved some attorneys. So I'm at the point now they want to go to a deposition here, and
I'm sorry, I can't hear her.
Okay. He's asking about a lawsuit that he had in the 20s, and they want to go to deposition about the lawsuit and things like that. Everyone needs to be liened, and then you need to terminate all corporate contracts with regard to that, and then speak by affidavit. So if you want to participate in that because there's some benefit that you feel is due, you can do that, but you got to do it by affidavit. So any questions with regard to deposition, they need to send the questions in the mail, and you will put the questions on your affidavit, and then you'll respond on your affidavit.
Okay, and there's no need to divulge, that I have a nationality, I have civil rights, or I'm in full life, or what have you.
You don't have civil rights. You don't claim civil rights. Civil rights is for civil citizens.
For citizens? Okay.
Yeah.
I have substantive rights.
You have sovereign rights.
Sovereign rights. Okay. All right.
Yep.
Okay.
Yes.
Okay.
That's that third piece that they didn't tell you about.
Right.
Sovereign rights.
That's right. Okay.
You know, because some say public rights, private rights, civil rights, whatever, all of that is sovereign rights.
Okay. All right.
You do need to divulge and disclose your nationality. You need to do that. And in reality, you're the judge on the case.
Okay.
So you're going to have to,
Well, when I use the affidavit, they'll see.
Yes.
With the court action. So, okay. All right.
Yes. Islam.
Islam. Thank you.
Peace and grand rising, everyone. Islam.
Grand rising.
I know
Islam.
you must be me.
Justice Kansu, I just love that you're with us. Thank you for being here.